Perkins.
Thank you. Next, for the prosecution, identify yourself for me, please, and tell us what your functions are today.
Good afternoon, Your Honor. My name is Marcus Winton. I will be conducting the direct examination of Ms. Kyle Cusack and the cross-examination of Professor Blake Van O.
Thank you, Mr. Winton. Finally, the final counsel, third counsel for the prosecution. Will you identify yourself, please, and tell me what you're doing for us today?
Yes, Your Honor. Good afternoon, members of the jury, opposing counsel. My name is Angel Hernandez. I'll be conducting the direct examination of Detective Jordan Markowitz, as well as the cross-examination of Ms. Avery Becker. I will also be presenting the closing argument for the prosecution. May our witnesses now introduce
Thank you,
themselves?
Mr. Yes, thank you, Mr. Hernandez. Let's start with your witnesses. Queue up and tell me who you are.
Good afternoon, Your Honor. Due to some Wi-Fi issues, myself and Ms. Burton will be sharing a computer. My name is Paige Funchy, and I am Jordan Markowitz.
Thank you. For the prosecution, go ahead.
Good afternoon, Your Honor. My name is Sherry Rangel, and I am Alex Cifuentes.
Thank you. Next.
Good afternoon, Your Honor. My name is Andrea Hernandez, and I am Kyle Cusack.
Thank you. Okay, so that is the full introduction for the prosecution team. Let's go to the defense side, starting with lead counsel, Ms. Nguyen. Tell me what you've got planned for me today.
Certainly. Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Clara Ann Wind, and today I and my co-counsel represent Avery Becker. Today, I will begin the closing argument as well as conducting the direct examination of Avery Becker and the cross-examination of Kyle Cusack. May my co-counsel introduce themselves?
They may. Go ahead.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Rachel Kidder, and I will be giving the opening statement, as well as conducting the direct examination of Professor Blake Van Owen and the cross-examination of Detective Jordan Markowitz.
Thank you, Ms. Kidder. On to the next witness, or the next attorney, sorry.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Landon Stuckey, and I will be conducting the direct examination of Taylor Perkins and the cross-examination of Alex Cifuentes. May our client and witnesses introduce themselves?
Yes, sir. Go ahead.
Your Honor, it appears
For the defense.
technical difficulties with the sound. If you would give us a moment to figure that out.
That's fine.
Is this better? Can you hear me now?
Yeah, there you go. Okay.
Okay, that's a relief. Thank
proceed.
you. Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Logan Holtzinger, and I am Professor Blake Van Owen.
Good afternoon, Your
Welcome,
Honor,
Ms. Holtzinger.
opposing counsel, Sorry.
Go ahead.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Shiloh Stuckey, and I am Taylor Perkins.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Melanie Mulcahy, and I am Avery Backer.
Thank you. That completes our introductions. Welcome, everyone. Okay, the next item is that I need to swear everyone in. So I would like to start with the team members, and that includes the lawyers and the witnesses. We'll start with the witnesses. If you'll all raise your right hands and respond in the affirmative. Do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? You need to say, yes, Your Honor.
Yes, Your Honor.
Yes,
Okay.
Your Honor.
Yes, Your Honor.
Okay. All right, on to the gallery members. Well, strike that. Let's go with the lawyers. Please raise your right hands. Do you promise that the presentation you're about to give will faithfully and truthfully conform to the facts and the rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
So lastly, gallery members, including teacher and attorney coaches, family members, and friends, do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round?
Yes, Your Honor.
Yes, Your Honor.
Thank you. All right, lastly, scoring panelists, raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
All right, thank you, everyone. Having dispensed with that, now I want to drill into some trial preliminaries. For the prosecution, do you have you circulated a copy of the stipulations as necessary?
Yes, Your Honor.
Okay, and for the prosecution, are there any preliminary matters of which you wish me to be aware?
Yes, Your Honor. First, we would like to clarify that pursuant to Rule of Competition 7.4, for the purposes of our online competition, exhibits that are displayed on the screen will not be shown to the jury unless we specifically request to publish. Exhibits may be shared on the screen for purposes of identification prior to admission.
For the defense, is there any objection to that, or are we comfortable with that process today?
We have no objection, Your Honor.
Thank you, Ms. Wind. All right, so I understand that that's how we will do it. We will deem the exhibits not viewed by the scoring panelists as jurors unless they are admitted and unless they are published, if that's acceptable. We will display them for purposes of laying foundation and admission, but from there we'll treat them as published only if I order them published. Anything else for the prosecution as a preliminary matter?
Additionally, while each of our attorneys and witnesses have made efforts to be in a setting with the best internet capabilities possible, if at any point the court cannot hear or see us, feel free to interrupt us at any time.
That's a very good point, Ms. Wind, and I'll do that for both prosecution and the defense. The way I want to handle this is pretty much the way we're doing it now. I will ask the lawyers and the witnesses who are on the record, if you will, who are on stage, to light up their screens and their microphones. Everyone else, I would ask to block out your screens and mute your mics so that we can just concentrate on the people who are performing. And when you're done performing, mute your mic, shut down your screen, and we'll go through it that way. Any other preliminary matters for the prosecution?
Yes, Your Honor. For the record, all witnesses will be present for the trial today and may not be sequestered pursuant to Rule of Competition 5.3.1.
I assume that's acceptable to the defense, correct?
Yes, Your Honor.
Thank you. Anything else for the prosecution?
No, Your Honor.
All right, let me pause for a moment. Ms. Wind, is there anything that you, of a preliminary nature that you wish me to be aware of?
Yes, Your Honor. First, that we request that the stipulated facts be received into evidence.
I will, because it's stipulated, I will allow the stipulated facts to be considered by the jury and to be part of the record. Anything else?
Yes, we ask that the clock be stopped in the case of any technical issues and that time not count towards either side.
Yes, I will ask the timekeepers to be aware of technical issues. If somebody says there's a technical issue, I would ask that the clocks be stopped until we can resume. If we have a real problem, then I'll sort it out. But that's a proper request. And of course, the clocks will stop during objections until I rule, and then resume once the ruling is complete. Anything further, Ms. Wind?
Nothing further, Your Honor.
All right. So having dispensed of the preliminary matters, it appears that we are ready to go forward with the trial. I will, what I will do between witness examinations, between direct and between cross and redirect, I will pause for a moment to allow the scorers to get caught up. I will not, well, let me say this, I will discourage recross. Unless something really extraordinary happens, we will have direct, cross-examination, redirect, and then move on. So with those preliminaries out of the way, I think we're ready to go. I would ask the prosecution, when you're ready, Ms. Burton, to deliver your opening statement.
Your Honor, before I begin, can you hear and see me okay?
I can hear you and see you perfectly. Thank you, Ms. Burton.
May it please the court. A knife
You may
in the back. I'm sorry, Your Honor. It seems I glitched out. What was that?
I glitched out, my mistake. Let's start the clock over, and when you're ready to begin, I will stand down and let you proceed.
Yes, Your Honor. A knife in the back. On March 6, 2020, Avery Becker made a rash decision and confronted her coach about their disagreements in the past. But like most rash decisions, things didn't go as planned, and Mackenzie Brackman was found dead later that day. However, this type of decision wasn't unusual for Miss Becker. In fact, just earlier that year, Miss Becker had made another rash decision and wrote Worst Attorney Award across the hood of her coach's beloved Porsche. This is just one example of Miss Becker's rash personality. However, throughout this trial, this topic will be brought up time and time again, as Miss Becker's former teammates and even best friend have previously described this trait in their affidavit. But let's talk about the day the murder took place. On March 6, 2020, Avery Becker and Taylor Perkins, who claims to be Miss Becker's best friend, skipped school to look for Miss Becker's alleged lost phone. Miss Becker claims to have lost her phone the day before the murder took place at the Fry Shack, even though it traces her to being near the victim's house at the time the murder took place. This is also the same phone that Miss Becker had previously used to admit her plans of breaking into Mr. Brackman's house to former teammate Alex Fuentes. However, as I previously stated, Miss Becker claims to have lost this phone just one day before the murder took place. Isn't that convenient? Throughout this trial, the defending party may try to distract you with alternate theories and even the victim's personality himself. However, as the prosecution, we have the burden of proof in today's case. We have to prove beyond a reasonable doubt on March 6, 2020, Avery Becker committed the offense of second-degree burglary and murder in the first degree. This means we have to prove beyond a reasonable doubt on or about March 6, 2020, Avery Becker unlawfully and feloniously committed the offense of second-degree burglary, and in the course, the death of Mackenzie Brackman occurred by Miss Becker. For us to prove our case beyond a reasonable doubt, we must not eliminate all possible doubt. After all, everything in life is open to some possible or imaginary doubt. A reasonable doubt is such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves, which is why at the end of today's case, there will be no reason to hesitate. You'll hear from Detective Jordan Markowitz, who's a certified homicide detective with Denver Police Department. During her testimony, she will walk you through the whereabouts of Miss Becker on the day the murder took place based on her cell phone records. You'll also hear from Kyle Kuzak, who is a certified reconstructive investigator. During her testimony, she will walk you through the procedure of gathering evidence and examining the residence. Lastly, you'll hear from Alexa Fuentes, who's a former teammate of Miss Becker and the one she had previously admitted her plans of breaking into Mr. Brackman's house to over text. After hearing all of this evidence, there will be no reason to hesitate. My co-counsel will ask you to return with a verdict of guilty. Thank you.
Thank you, Ms. Burton. Pause for a moment before we ask Ms. Kidder to provide an opening statement for the defense. Just a moment. All right, for the defense, you may proceed with your opening statement, Ms. Kidder.
Don't judge a book by its cover. That applies to this case too. The prosecution just showed you a book with an interesting cover. A high school mock trial coach murdered by an upset team member. However, at this trial, we will open that book for you and show you that the pages are garbled and illegible because the evidence does not support the cover. The title of this book should be, "We Have to Blame Someone." However, that is never a reason to charge an innocent person with murder. Good afternoon, members of the jury. My name is Rachel Kidder, and I, along with my co-counsel, represent Avery Becker, a college student who has been falsely accused based on misinterpreted evidence from a misguided investigation by a mistaken detective. By the end of this case, you'll be able to see just how bad the story under the cover really is. Today, you'll hear about Mackenzie Brackman's murder, but you will hear nothing of my client's involvement because she did not kill Mr. Brackman, and the person who might have committed this crime wasn't even investigated by the police. Mackenzie Brackman was found deceased in his home on March 6, 2020. He was a criminal defense attorney and a volunteer mock trial coach. The police almost immediately focused the investigation on a high school student on Mr. Brackman's mock trial team, our client Avery Becker. She'd been kicked off the team, and the police believe that that is enough motive for murder. The lead that they refused to follow, the pages of this book that would have made it fact and not fiction, pointed not to our client, but to someone who had real motive to harm Mr. Brackman. As the judge will instruct you at the end of this case, it is the prosecution that has the burden of proving beyond a reasonable doubt that Avery Becker committed second-degree burglary and first-degree murder. Beyond a reasonable doubt, members of the jury, let that sink in. By the end of this case, to decide my client is guilty, you must not have a single reasonable doubt about any of the elements of either of these crimes. We believe the prosecution cannot meet that burden. We will open this book for you today and show you what's missing. What's missing is Avery Becker, who was never at the scene of the crime and during the time of the murder was with a friend miles away from the home. The evidence will show that Mr. Brackman and our client didn't like each other. We agree they didn't have a good relationship, but that is a far cry from being willing to murder. Mr. Brackman and our client had a falling out after a mock trial practice. Ms. Becker accidentally caused permanent damage to Mr. Brackman's car. She then went to his office, offered to pay for the damage personally, and tried to apologize to him, not to harm him. The prosecution will try and tell you she was really planning on vandalizing his house. Members of the jury, we will show you this is not true. But the most important fact is that during the time of the murder, Avery Becker was with her friend miles away from the home. We will first call Professor Blake Van Owen, an expert in criminal investigations, who will testify that the police chose the desired outcome before the investigation even started, rushed the investigation they did conduct, and didn't even look into someone with much greater motive. This person was full of rage and wanted revenge because Mr. Brackman lost the criminal case that sent their father to prison for life on the charge of murder. This person was never considered during the police's investigation. We will next call Taylor Perkins, who will testify that she was with Ms. Becker the entire day of the murder. Their stories will match down to the minute. And finally, we will call Avery Becker, who will testify to her poor decisions and will admit to her mistakes, but she will also testify she had no desire to harm Mr. Brackman, and she was with Taylor Perkins the entire day of the murder. She will testify her phone was stolen the day before the murder, and any messages or cell phone data coming from that phone did not come from our client. The prosecution will call the detective whose rushed investigation accused the wrong person, the person who stole our client's cell phone, and a crime scene reconstructionist whose testimony is so confusing and contradictory that you won't know what to believe by the end. Members of the jury, after you've heard this case, we believe you will agree. The police did not investigate the right person, and Avery Becker had nothing to do with this crime. That is why at the end of this case, we will ask you to find Avery Becker not guilty of murder and expose this case for what it really is, just another ugly cover. Thank you.
Thank you, Ms. Kidder. Pause for a moment before we call prosecution witness number 1. All right, the prosecution may call its first witness.
Yes, Your Honor. The prosecution calls Detective Jordan Markowitz to the stand.
May I have a moment to change the screen name?
You may.
Thank you, Your Honor.
Mr. Hernandez, you may proceed.
Your Honor, before I begin, can you see and hear me okay?
Yes, thank you.
If at any point those conditions should change, please do not hesitate to let me know so I can identify and fix the problem.
I'll let you know. Thanks.
Good afternoon, Detective. Could you please introduce yourself to the jury?
I'll let you know.
Good afternoon. My name is Detective Jordan Markowitz.
Detective, what is your role in today's case?
I am the lead detective assigned to the murder of Mackenzie Brackman.
And what education or experience did you receive to become a detective in the first place?
Well, I've spent 13 years with the Denver Police Department, 7 of which I've been a homicide investigator. I've also received specialized training in the area of cell phones.
And what kind of experience or education do you have in respects to cellular phones?
Well, I'm qualified in the collection of forensic data, cell phone data, and cell tower data, as well as the analysis of each of those.
And how often would you say that you use that certain area of expertise?
I use it I use it very often in my investigations.
Your Honor, at this time, I ask that Detective Jordan Markowitz be recognized as an expert in the field of homicide investigation with an emphasis on cellular phone technology.
For the defense, any objection or inquiry?
No objection, Your Honor.
There being no objection, the witness will be qualified as an expert in the area of homicide investigation with an emphasis on cellular telephones.
Yes, Your Honor. Now, Detective, focusing on the case, when exactly did you arrive at the crime scene?
I arrived at the crime scene at around 14:20 or 2:20 p.m.
And what were your first impressions of the crime scene?
Well, I immediately noticed that there was a video camera doorbell system installed at the house, and that the victim was laying partially in and partially outside of the front door.
You've just mentioned a camera system. Were there any cameras around the exterior of the house?
Yes, there were 4 total cameras, from which I downloaded some videos after I started my investigation.
Your Honor, at this time, I ask that my trial technician be allowed to display their screen to show exhibits 10 and 13 for purposes of identification.
Counsel, may we start with witness or with the exhibits one at a time? And I assume counsel for the defense has no objection. It can start with exhibit 10. Is that acceptable?
Yes, Your Honor.
Mr. Hernandez, is that all right?
Yes, Your Honor.
Okay, exhibit 10.
Detective, do you recognize this exhibit?
Yes, this is the link to the video downloaded from the doorbell system.
And is it accurate to the best of your knowledge?
Yes, it is.
Your Honor, at this time, I ask that exhibit 10 be admitted into evidence.
Any objection or inquiry from the defense?
No objection, Your Honor.
The exhibit 10 may be admitted and at the request of counsel may be published.
And as such, Your Honor, may I publish to the jury?
You may.
Detective Markowitz, as this is playing out, what does exhibit 10 reveal to the jury? Your Honor, it would appear that my witness is experiencing some technical issues. If I could ask that the timekeeper stop the
As
time.
you see, as the video plays, a masked intruder will reach a front door that belongs to Mackenzie Brackman's residence, and in a moment you have time to enter the house through a locked door.
Mr. Hernandez, I will honor your request that we pause the time until we're certain we have a good connection with your witness. Although her audio is coming through delayed, it's pretty clear to me her video is frozen. So let's pause for a moment and see if we can straighten that out.
Yes, Your Honor. Detective, let us know when you believe you have sorted out the issue.
I don't appear to be having any issues on my end. I'm not sure why it is not coming through. I'm not sure what I can do to fix it.
All right, Mr. Hernandez, you may resume and we will restart the clock.
Yes, Your Honor. Now, Detective, again, for the jury, could you describe exactly what Exhibit 10 reveals?
Of course. Exhibit 10 reveals a masked intruder approaching the front door of Mackenzie Brackman's house. This intruder attempts to enter the house, but seeing as the front door is locked, they move around to the back.
And now, Your Honor, I ask that my trial technician be allowed to display Exhibit 13 for the jury. For purpose of identification, excuse me.
You may.
Detective, do you recognize Exhibit 13?
Yes, I do. It is the link to the video downloaded from the Ring camera.
And is it accurate to the best of your knowledge?
Yes, it is.
Your Honor, at this time, I ask that Exhibit 13 be admitted into evidence.
Ms. Kidder, any objection or inquiry?
No objection, Your Honor.
Exhibit 13 will be admitted and published at the request of counsel.
Yes, Your Honor, and again, as such, may I publish to the jury?
You may.
Now, Detective, could you just explain what just happened in Exhibit 13?
Of course. As you can see, the same masked intruder is seen fleeing through that front door, which had been previously locked.
Thank you, Ms. Mintz. You may now stop sharing your screen. Detective, pertaining to your knowledge with cellular phone technology, were you able to obtain any information from the victim's phone?
Yes, I searched the victim's phone and I found an extensive amount of emails and text messages relating to something called mock trial, which I now know is a high school program relating to law.
And did you look any further into this mock trial program?
Yes, I did. I contacted the school that the victim had previously coached for and obtained the student records for the team.
Did you contact anybody on that student record?
Yes, I did. I contacted several students, one of which gave me a large break in the case.
Who exactly was this contact that led you to a great breakthrough in your investigation?
Alex Fuentes was the contact.
And who exactly is Miss Alex Fuentes?
Alex Fuentes is a senior on the team this year who was teammates with Avery Becker, the student that they made me aware of.
And was Miss Becker ever brought in for an interview?
Yes, she was.
And what kind of information were you able to obtain through that interview?
I was able to interview Alex Fuentes personally, and Alex Fuentes gave me information from Avery Becker, a set of text messages between the two of them containing Avery Becker's intention to break into and vandalize Mr. Brackman's home.
Your Honor, at this time, I ask that my trial technician be allowed to display Exhibit 14 for purposes of identification.
I will so permit.
Do you recognize Exhibit 14?
Yes, I do. Exhibit 14 is the text messages that Alex Fuentes gave to me.
And is this exhibit accurate to the best of your knowledge?
Yes, it is.
Your Honor, at this time, I ask that Exhibit 14 be admitted into evidence.
Ms. Kidder, any objection or inquiry?
Yes, Your Honor, we object on the basis of foundation. This witness did not create these screenshots. She does not know whether or not they're an accurate copy of the messages, as she never actually saw the messages herself. We believe there is a witness here today that could admit these into evidence, but it is not Detective Markowitz.
Mr. Hernandez, a response.
Your Honor, in pursuant to Rule 901, a witness can authenticate an exhibit so long as they have knowledge of a copy, and as Detective Markowitz has been able to speak to her knowledge of this exhibit and how she was able to pertain it from Miss Alex Fuentes, it is an authentic exhibit that she can speak on.
Ms. Kidder, a response to the 901 or reply to the 901 response.
Yes, Your Honor, I still believe that this witness does not have sufficient foundation to admit this into evidence, as she cannot verify whether or not these are accurate to the originals.
Pause for a moment. I believe the witness has testified that she received these images from the witness Fuentes, and based upon that foundation, I will overrule the objection and leave to the jury the weight to be given to these statements, and also leave to the defense the opportunity to rebut or refute these statements. So Exhibit 14 is admitted.
Yes, Your Honor. Now, Detective, excuse me, Your Honor. May I publish to the jury?
You may.
Now, Detective, what does Exhibit 14 display?
Well, as you can see in Exhibit 14, the person in the gray labeled Avery Becker, it states their intention to break into and vandalize Mr. Brackman's house if they do not let him back on the team.
Thank you, Ms. Mintz. You may now stop sharing your screen. Detective, now having knowledge of the defendant, how did you proceed with your investigation?
Well, I attempted to contact the attorney in order to get an interview with Avery Becker. However, I was denied an interview. I was given the defendant's phone number, and I used that to try and find their phone to obtain their copy of the text messages.
At any point in your investigation, were you able to exercise your expertise in cellular phone technology?
Yes, I was. Unfortunately, I had been informed that the defendant had apparently lost the phone the day before the murder. And I was able to contact the service provider and obtain CDR records, which give a general location of where the phone is when it's active.
And how exactly did you proceed with these call detail records?
The call detail records gave me the position of Avery Becker's phone during the time of the murder. And with that, I was able to determine who was the main suspect in this case.
Your Honor, at this time, I ask that my trial technician be allowed to display what has been previously marked as Exhibits 15 and 16 for purposes of identification.
Counsel, if you don't mind, I would like them displayed one at a time. We'll start with 15. Ms. Kidder, any objection to that?
No objection, Your Honor.
Thank you. Mr. Hernandez, Exhibit 15 first.
Yes, Your Honor. Detective, do you recognize Exhibit 15?
Yes, I do.
Could you give a short description of what exactly we are looking at here?
Exhibit 15 is a map with the 3 cell towers that Avery Becker's phone contacted on March 6th.
And is it accurate to the best of your knowledge?
Yes, it is.
Your Honor, at this time, I ask that Exhibit 15 be admitted into evidence.
Any objection or inquiry from the defense?
No objection, Your Honor.
There being no objection, Exhibit 15 will be admitted. And counsel, do you wish to publish it?
Yes, Your Honor.
Granted.
And now Exhibit 16, Ms. Mintz. Detective, do you recognize Exhibit 16?
Yes, I do. Exhibit 16 is largely the same as 15 with the addition of the most likely route the defendant took on the day of the murder.
And is it an accurate depiction to the best of your knowledge?
Yes, it is.
Your Honor, at this time, I ask that Exhibit 16 be admitted into evidence.
Ms. Kidder, any objection or inquiry?
No objection, Your Honor.
There being no objection, Exhibit 16 will be admitted.
Yes, Your Honor. Now, Ms. Mintz, if you could go back to Exhibit 15. Detective, what exactly is Exhibit 15 able to reveal to us today?
Exhibit 15 shows the 3 cell towers that Avery Becker's phone connected with on March 6th during the time that the murder occurred. It also shows the general geographic location of that phone.
And moving to Exhibit 16, what does this reveal?
This is largely the same. It still has the general geographic location, but I made the addition of the most likely route the defendant's phone took during the times of the murder.
Thank you, Ms. Mintz. Now, Detective, with the accumulation of all the evidence you have spoken to here today and the rest of your investigation, who does it all point to?
The evidence pointed me to Avery Becker.
Thank you, Your Honor. No further questions.
Thank you, Mr. Hernandez. We'll pause for a moment for the scoring judges to catch up a bit. Ms. Kidder, you may cross-examine.
Good afternoon, Detective. I have a couple questions for you as well. First, I'd like to talk to you about your initial consideration of this case. When you first considered the evidence at the scene, you thought this could be the work of a disgruntled ex-client, didn't you?
Yes, I did.
You thought this because Mr. Brackman was a defense attorney, wasn't he?
Yes, he was.
And if he represented someone who lost and thus became a disgruntled ex-client, that could be motive for murder, couldn't it?
It could, yes.
You ultimately concluded it was very unlikely, however, that it was an ex-client of Mr. Brackman's, didn't you?
There simply wasn't enough evidence.
But by that same vein, you also concluded it was highly unlikely that Mr. Brackman's activity in high school mock trial had anything to do with this investigation, didn't you?
Not necessarily, no.
You do not believe that you thought at one point that his activity had anything to do with this case?
I'm not sure what you mean. I didn't think initially that this had anything to do with high school mock trial, but after further investigation, the evidence did point me to it.
About the day of the murder, you concluded that Mr. Brackman armed himself, correct?
Yes.
Then confronted and struggled with the intruder.
Yes, that made the most sense.
And then the intruder got the knife away from him and Mr. Brackman was stabbed. Wasn't that your conclusion?
Yes, it was.
However, isn't it true that the coroner's report shows no other injuries to Mr. Brackman other than the stab wound?
It does.
The coroner's report does show other injuries to Mr. Brackman?
No, it shows only the stabbing.
Thank you. Now I'd like to talk about the issue of cell phone data in this case. You focused on Avery Becker's cell phone, correct?
I did.
And you were not able to confirm whether or not Avery Becker was with her phone, as you obviously weren't there to see it.
No, I was not there on March 6th.
But you did see, however, that Avery Becker's phone was receiving multiple unanswered texts and calls from Taylor Perkins' phone, didn't you?
I was not sure whose phone was calling them, but yes, it had multiple unanswered calls.
You were not able to tell who was calling Avery Becker?
Sorry, I couldn't hear you. You cut out for a second.
You were unable to tell who was calling Avery Becker?
Initially.
Did you write a witness statement for this case?
I did, yes.
And if you could please turn to that witness statement. And
at the moment, I'm unable to.
We're screen sharing it for you, Detective. At the top of this document, do you see where it says Detective Markowitz, expert witness statement, prosecution?
Yes, it does.
And if you will go to the bottom of that witness statement, do you see, once we get there, do you see your signature there?
I appear to be lagging. Hold on just a second. Yes, I do.
And you see reading at line 188, I have carefully reviewed this statement. It is true and accurate.
Yes.
Thank you. Now, if you could please turn to line 145 on page 16. On line 145, you state Perkins was calling Becker, but Becker was not answering. Did I read that correctly?
Yes.
When Taylor Perkins spoke with the police, she did tell them that she was with Avery Becker on the day of the murder, correct?
Yes, she did.
And when someone claims to be with a defendant during a time of a crime, that's called an alibi, isn't it?
It is.
And you did not investigate this alibi.
There simply wasn't enough evidence to make it feasible.
Now I'd like to talk to you about some more things that didn't happen in this investigation. You testified on direct to some screenshots.
May I be heard?
Mr. Hernandez.
Opposing counsel is about to speak to things that did not happen in this investigation and as such pertain no relevance to the case at all, pursuant to Rule 401.
Appears to be a relevance objection. Ms. Kidder, your response.
Your Honor, we are attempting to prove that the police investigation in this case was inadequate and not investigating an alibi and not thoroughly authenticating evidence is extremely relevant to this case.
Mr. Hernandez, a reply.
Your Honor, further, Detective Markowitz has spoken to the fact that he has qualified every bit of evidence that pertains specifically to this investigation, and as such, anything that falls outside that scope is not relevant to today's case.
Thank you, counsel. I will overrule the objection and conclude that this does tend to prove something material in the case. You may proceed.
Detective Markowitz, you testified to screenshots that a teenager sent you on your direct examination. Do you recall that?
Yes, I was sent screenshots by Alex Cifuentes.
You wanted to see that actual phone, though, didn't you?
I did.
But Cifuentes never gave it to you, did she?
Their phone was gone by the time I was able to obtain the screenshots.
So without access to that actual phone itself, you also couldn't download any information from it or look at the messages for yourself, could you?
Unfortunately, by the time it had been gotten rid of.
And this might have been the only time in your 13 years of law enforcement that you have ever known of a teenager to be without their cell phone. Isn't that right?
Yes, it was a little bit strange.
So you did not obtain Alex Cifuentes' cell phone, and you also did not obtain my client's cell phone, did you?
No, both phones were lost at the time.
Next, and maybe most importantly, you did not do a detailed investigation of Blair Rollins, did you?
There wasn't enough evidence to deem Blair as a suspect.
You didn't do that investigation despite Kyle Cusack identifying Blair Rollins as a suspect in this investigation?
They were identified as a suspect, but without proper evidence, they were dismissed.
If you could please turn to Exhibit 16, which has already been admitted into evidence. In this exhibit, you place the location of Blair Rollins and Avery Becker living in the same cell tower sector. Isn't that right?
Yes.
And that blue line down the middle is the path you believe Avery Becker took to get to Mr. Brackman's house that day. Isn't that right?
Yes, it is.
And according to this map that you created, Blair Rollins could have had that phone, taken a nearly identical route, and hit the same cell tower sectors, correct?
Could have, but it's highly unlikely.
Next, I would like to turn your attention to the videos in this case, specifically Exhibit 12. You have seen these videos before, haven't you?
Yes, I have.
And they are fair and accurate videos that you obtained over the course of your investigation?
They are.
If you could please turn to Exhibit 12. Do you recognize this exhibit?
That is the link to the video, yes.
And that's a fair and accurate copy of the video?
Yes, it is.
Your Honor, the defense offers Exhibit 12 into evidence.
Mr. Hernandez, any objection or inquiry to Exhibit 12?
No objection, Your Honor.
Permission to publish, Your Honor?
Exhibit 12 will be admitted and permission to publish is granted.
Detective Markowitz, in this video, you can see the intruder look into the home before entering, can't you?
Yes.
And you went through this same glass door when doing your own investigation of the home, correct?
It's standard to do a walkthrough, yes.
And when you enter through this glass door, you enter directly into the kitchen where you say Mr. Brackman and the intruder struggled, don't you?
Yes, I do.
Finally, the video in this case shows the intruder wearing a mask, a hoodie, and gloves, correct?
It does.
At no time have you ever mentioned law enforcement collecting a mask from my client, have you?
No, we were unable to search their house.
At no time have you ever mentioned law enforcement collecting gloves from my client, have you?
No, they were disposed of.
And at no time have you ever mentioned law enforcement collecting a hoodie from my client, have you?
No.
In fact, you never mentioned a search even being made for these items.
No.
No more questions, Your Honor.
Thank you, Ms. Kidder. We will pause for just a moment before redirect. Mr. Hernandez, your witness.
Yes, Your Honor, but first may I inquire as to how much time the prosecution has remaining?
You have 12 minutes and 42 seconds remaining.
May I proceed, Your Honor?
You may.
Detective Markowitz, what exhibits have you spoken about on this trial?
I believe I've spoken to 15, 16, 10, 12, and 13, as well as 14.
And each of those exhibits were important in what way?
I'm sorry, what now?
And each of those exhibits were able to display what kind of element to the jury?
They displayed the attention of Avery Beckers to break into and vandalize Mr. Brackman's home. They also displayed the intruder entering the home.
And how much significance did these exhibits hold?
They were very important.
And they all draw to which person?
Avery Becker.
Thank you, Your Honor. Nothing further.
Thank you, Mr. Hernandez. We will pause for a moment and then the prosecution may call its next witness. And counsel may light up their screens, unmute their mics, and the witness is also free to do the same.
A moment, Your Honor, while we readjust the camera.
You may. Ms. Burton, are you ready to proceed?
Yes, Your Honor. Before I
All right,
begin,
and for
can you
the-
hear and see? Excuse me.
Hang on just a moment. I am not seeing counsel for the defense with a live screen yet. May I ask? There you go. Mr. Stuckey, welcome. All right, let's proceed. Ms. Burton, your witness.
Your Honor, the prosecution calls Alex Fuentes to the stand. Before I
Ms. Win-
begin, can
Ms.
you hear and see me all right?
Yes, I can hear and see you fine. Let's test the witness's microphone briefly.
Hi, Your Honor. My name is Alex Fuentes.
Thank you. Mr. Stuckey, let's check your mic.
You hear me, Your Honor?
Oh, yeah. Okay. Ms. Burton, you may proceed.
Good afternoon. Please introduce yourself to the jury.
Hi, my name is Alex Fuentes.
Ms. Fuentes, could you please explain how you're connected to the case today?
Avery and I were both on the Colorado High mock trial team.
And how long have you been on the team together?
We both joined freshman year. Actually, it was Avery who got me into joining the team.
So how would you describe your relationship with Miss Becker?
We never really saw eye to eye in mock trial. Avery doesn't put in any work for the team. She was always late to practices and wasn't prepared for tournaments and practices. I take mock trial very seriously. I'm always reading the case, getting on my direct and cross examination, and Avery doesn't.
So how would you describe your time on mock trial?
Like I said, I take mock trial very seriously. And Avery, I take mock trial very seriously and try to succeed. And Avery succeeds without trying as hard as the other members, which always made Coach Brackman mad.
On that note, could you please describe Avery and your former coach's relationship?
Yes. Avery
Objection, Your Honor. Lack of foundation.
Ms. Burton, a response, I mean.
Your Honor, I am simply trying to lay foundation to how Ms. Fuentes knows Ms. Becker from mock trial, as she has previously stated.
I will sustain the objection, as it appears that Ms. Burton is going to ask a few more questions to pull out the witness's familiarity with the relationship about which counsel just inquired. Ms. Burton, lay a little more foundation.
Yes, Your Honor. Ms. Fuentes, you were on a team with Ms. Becker and your former coach for over 3 years, correct?
Yes, Avery and I, we were on Team A together.
And would you say, based on your observations from this time, you could give an accurate description of somewhat of their relationship?
Yes, I can.
On that note, to the best of your abilities, could you describe Avery and your former coach's relationship?
Avery and Coach Brackman always argued about Avery's lack of commitment towards the team and how she is never prepared for tournaments and practices. Things got worse after the car incident with Coach Brackman's car.
And what happened at practice before this incident?
Avery had won the Best Attorney Award in a previous competition, and she and Coach Brackman got into an argument about how she shouldn't be confusing good showmanship with good lawyering and saying stuff like she really didn't deserve that award.
And could you explain the incident with your coach's car more in detail?
After practice, we usually write our ideas down while leaving. I saw Avery grab a permanent marker. She vandalized Coach Brackman's car.
Objection, Your Honor.
Award.
Hearsay.
Response.
Your Honor, this is not hearsay, as it is being offered to prove the truth of the matter asserted pursuant to Rule 801.
Reply, Mr. Stuckey.
Your Honor, this witness did not see this event take place, therefore it's hearsay, and this is most definitely being offered for the truth of the matter being to explain the relationship between Mr. Brackman and Ms. Becker.
I will overrule the objection because it does not appear that the witness is being asked to testify to statements by a declarant. The witness is being asked to testify to observations of conduct by the defendant. Overruled. You may proceed, Ms. Burton.
Ms. Fuentes, would you like me to re-ask the question?
Yes, please.
Could you please explain the incident with your coach's car more in detail?
After practice, We write ideas down while leaving. And I saw Avery grab a permanent marker. She vandalized Coach Brackman's car, writing words attorney wrote across his beloved Porsche.
How did the victim react to this?
Well, for starters, Avery was kicked off the team, and she later on texted me asking if I could talk to Coach Brackman.
Your Honor, at this time, I ask that our trial technician please pull up Exhibit 14, which has previously been admitted into evidence.
Permission granted. Go ahead.
Ms. Fuentes, could you please explain what these are?
These are the messages Avery sent to me asking if I could talk to Coach Brackman about letting her back on the team.
And did you talk to the victim?
Yes, I did, but he wasn't interested in letting her back on the team. Avery wasn't committed to mock trial, so why would she get back on the team? It doesn't make any sense.
After talking to your coach, did you talk to Ms. Becker again?
I told her.
Objection,
that
Your Honor. Hearsay.
Response, Ms. Burton.
One second, Your Honor. Your Honor, this statement is referring to one of the messages in Exhibit 14, which has already been previously admitted into evidence and therefore is not hearsay.
Mr. Stuckey, a reply?
Your Honor, if this statement is indeed referring to a text message within Exhibit 14, then I withdraw my objection.
All right, I believe the witness was testifying to what the witness said to the defendant, and that was the objection. But it appears that counsel is focusing on the text messages, so I will overrule the objection. You may proceed.
After talking to your coach, did you talk to Ms. Becker again?
Yes, I texted Avery letting her know that he wasn't interested. And Avery seemed really angry, and she started to say stuff like she said that what she did to Coach Brackman's car was nothing.
And did Ms. Becker say anything else about what she was planning?
I asked her what she meant by that, and she texted me saying that she was going to break in and trash his house.
And was that the last you heard from Ms. Becker?
Yes, after that, she really didn't text me again, and we all went our ways after the incident.
Moving on, let's talk about your interview with Detective Markowitz. Did you share these messages in your initial interview?
I had mentioned the messages to Detective Markowitz, but I didn't have my phone on me, so she just asked if I could send her screenshots.
Objection, Your Honor. Hearsay.
The response to the hearsay objection, Ms. Burton.
Your Honor, again, this is not hearsay, as it is not being offered to prove the truth of the matter asserted, but rather just based on the witness's observations and perspective.
Reply, Mr. Stuckey.
Your Honor, the asking from Ms. Markowitz to Alex Cifuentes is a way of proving the credibility of the police's investigation, and this is most certainly being offered for the truth of the matter.
I don't agree. I will overrule the objection. It does not appear that the statement is being offered to prove the truth of the matter based on counsel's representation. You may proceed.
And why didn't you have your phone with you, Ms. Cifuentes?
Honestly, it was a pretty old phone and didn't stay charged for so long, so I just forgot to grab it on the way out the door.
Ms. Cifuentes, after your brief conversation with the defendant containing Ms. Becker's words, break in and trash, do you believe Ms. Becker was angry enough with your former coach to make a rash decision?
Avery definitely had a lot of mixed emotions, but after the car incident, I wouldn't put it past her if she had made a reckless decision.
Thank you, Your Honor. No further questions.
Thank you, Ms. Burton. We will pause for a moment before Mr. Stuckey cross-examines the witness. Mr. Stuckey, you may proceed. Cross-examination.
Good afternoon, Ms. Fuentes. I have a few questions for you as well. Your testimony under oath today is that although you and Avery didn't see eye to eye within mock trial, you were basically best friends with Ms. Becker, right?
Yes, we were really close friends.
But let's talk about how you viewed your best friend. First, you wondered why Mr. Brackman even put up with Ms. Becker on the mock trial team, right?
Yes.
And you didn't like the way that your best friend treated the team or Mr. Brackman, did you?
No, I did not.
And you thought that Ms. Becker always played the victim, right?
Yeah, it seemed like it most of the times.
You thought that Avery Becker won mock trial awards without any real talent, right?
I'm sorry, can you restate the question?
You stated that Ms. Becker won some mock trial awards. You thought that your best friend won these awards without any real talent, right?
Yeah, I guess you can say that.
You agreed with Mr. Brackman demoting your best friend to the B team, right?
Yes, she didn't really put in any work, so she just got demoted to B team for not putting any work for the team.
So you didn't even want your best friend on the same mock trial team as you, isn't that right?
Well, if she wasn't putting any work for the team, she should just go be demoted to B team.
Right. And in addition to not wanting Miss Becker on the same mock trial team as you, you thought that Mr. Brackman should have pressed criminal charges against Miss Becker for what happened to his car, right?
Yes, she vandalized his car, so yes.
Let's talk about the charges before this court today. While this case was being investigated, you did not hesitate to speak with the prosecution investigator, did you?
No, I didn't.
But you had no interest in speaking with the defense side representing your best friend, isn't that right?
I can't answer that with a yes or no. The defense attorney did come to my house to come talk to me, but I already knew what was happening.
So you refused to speak with the defense investigator, right?
Yes.
Let's talk about those text messages that you've testified about on direct. You don't have that cell phone anymore, do you?
No, my parents bought me a new one.
And the police did not even ask you to keep that cell phone, did they?
No, I don't recall.
Despite your belief that you're skilled at mock trial, your testimony under oath today is that you got rid of evidence relevant to a murder trial, right?
I wasn't asked to bring the phone, well, after my interview with Detective Markowitz.
But like you said, you did get rid of the cell phone that contained the text messages from Miss Becker, right?
Yes, my parents bought me a new one, as I stated previously.
Everyone in the courtroom knows your testimony that the text messages indeed came from Miss Becker, but for the record, you never saw her type or send those texts, did you?
I don't understand your question.
You never saw my client type out those texts or send them, did you?
I still don't understand your question. I'm sorry. Can you rephrase it?
Even though you've testified that Ms. Becker texted you, you never perceived her or saw her typing or sending those texts, did you?
No, I did not.
Ms. Fuentes, in one of those text messages that you've testified about from basically your best friend, Avery Becker, who is a saved contact in your phone, she identified herself by name, didn't she?
Yes.
You said on direct that Ms. Becker told you she was going to do something to Mr. Brackman's house, right?
Yes.
In fact, you received text messages and you believed them.
Yes.
Correct? But you never, at any point in time, warned Mr. Brackman about that, did you?
No, I did not.
And you never called the police or alerted any authorities about that.
No, I didn't.
In fact, it was not until 3 months after Mr. Brackman's death, when the police called you, that you decided to inform them about these text messages. Isn't that right?
Yes, Detective Markowitz asked for an interview.
3 months after Mr. Brackman's death, right?
Yes, unfortunately.
Thank you. No further questions, Your Honor.
Thank you, Mr. Stuckey. We will pause for a moment before redirect. Ms. Burton, you may proceed.
Before I begin, may I inquire to how much time I have remaining?
You have 5 minutes and 54 seconds left.
My
Based on,
timer reads 5 minutes and 47 seconds.
based on that information, there will be no redirect.
Thank you, Ms. Burton. Waiving redirect at this time. The witness may step down. Pause for just a second to get the prosecution's third witness on the stand, screen lit up, mic activated, and let's have counsel do the same. All right, we have for the prosecution, Mr. Winton, is it?
Yes, Your Honor.
All right. Mr. Winton, it appears your witness is in the chair and counsel for the defense is ready, so you may proceed with direct examination of prosecution witness 3.
Good afternoon. Could you please introduce yourself to the jury?
Good afternoon. My name is Kyle Kuzak.
Why are you here today, Ms. Kuzak?
I worked as a crime scene reconstruction investigator, or CSR for short, with the Denver Police Department, and I reconstructed the murder of Mr. Brackman.
Could you explain to us how you obtained this position?
I have over 19 years of experience with crime scene reconstruction. I've worked on everything from burglaries, home invasion, to domestic violence and homicide.
Your Honor, at this time, the prosecution moves to tender Ms. Kyle Kuzak as an expert in the field of crime scene reconstruction.
Ms. Wind, any inquiry or objection?
No, Your Honor.
Without objection, then the court will admit the witness as an expert in the field of crime scene reconstruction. Correct, counsel?
Yes, Your Honor.
You may proceed.
Ms. Kuzak, could you explain to the jury how you prepare for reconstruction?
Of course, I work under a 5-step process: recognition and documentation, collection of evidence, evaluation of evidence, hypothesis and testing, and finally, reconstruction.
Do you prepare any sort of tracking sheet or spreadsheets for your reconstructions?
Yes, I begin by creating a witness tracking spreadsheet. This allows me to compare each witness's stories with what the physical evidence says. I then make a timeline. This timeline and the flowcharts, they help me not get lost into too much detail and focus on the big picture.
Your Honor, may my trial technician display Exhibit 17 for the witness?
You may.
Ms. Kuzak, do you recognize this?
Yes, I do.
And is it fair and accurate to the best of your knowledge?
Yes, it is fair and accurate.
Your Honor, at this time, we move to admit Exhibit 17 into evidence.
Any objection, Ms. Kidder?
I have no objection, Your Honor.
Exhibit 17 will be admitted.
May we publish to the jury?
You may.
Thank you, Ms. Mintz. You can take the exhibit down now. Ms. Kuzak, could you walk us through the day of Mr. Brackman's murder?
Yes. On or about March 6, 2020, A person matching the physical description of the defendant, Avery Becker, approached the front porch and attempted to enter through the front door of the victim's residence, though the door was locked.
So where did they enter from?
The intruder then went to the south side of the residence, passing a fence gate and finding a sliding glass door.
What did they do once they were in the residence?
Well, the victim had been alerted of the intruder and had gone to grab a knife in order to defend himself against the intruder.
What happened next?
The victim and the intruder had been engaged in close contact, working to obtain the knife that the victim was holding.
What happened with this knife?
Well, the intruder had, after a struggle, the intruder had obtained the knife through a bear hug type motion and had been able to stab the victim through the shoulder, nicking the top of the heart.
Now, finally, are you aware of Professor Van Owen's conclusions in today's case?
Yes, I am aware.
And what do you think about the validity of these conclusions?
Well, I don't agree with most of them. For starters, beside what Mr. Van Owen believes...
Objection, Your Honor. My objection is to improper character evidence.
The response to a character evidence objection, Mr. Winton.
Your Honor, as we are not showing any sort of character trait nor specific instance of conduct, this is not character evidence.
I will overrule the objection on that basis. You may proceed.
Would you like me to re-ask the question?
Yes.
Do you think there is any validity to Professor Van Owen's conclusions in today's case?
Yes. Unlike what Mr.
Objection, Your Honor. This testimony invades the province of the jury.
Mr. Winton, a response.
Your Honor, the witness is testifying in her expert opinion to refute the claims of Professor Van Owen, who is a defense expert, and is simply offering more insight to the jury to the validity of the claims of Professor Van Owen.
Ms. Wynn, do you care to reply?
Yes, Your Honor. This witness, if allowed to testify, would come to conclusions that are only the jury's decision to make based upon the evidence that they hear. This witness has no right to make those conclusions for those jury, and therefore it invades the province of the jury, and under Rule 704, it is an opinion on an ultimate issue, which is not allowed.
Your Honor, may I respond?
Thank you. I know I'm prepared to rule. Ms. Wind, although you do correctly cite the rule on opinions as to ultimate issues, I am going to find that the question does not elicit an opinion on an ultimate issue, but it does solicit an opinion on the credibility of another witness, which, although within the province of the jury, is not an ultimate issue. I will overrule the objection. You may proceed, Mr. Winton.
Ms. Kuzak, what do you think about the validity of Professor Van Owen's conclusions?
Well, Mr. Van Owen believes that there was no struggle, but there is clear evidence of a struggle through the broken plate, the scuff marks. It is all clear evidence of a struggle between the victim and the intruder.
Thank you, Your Honor. No further questions at this time.
Thank you, Mr. Winton. Let's pause for a moment for the scoring judges to catch up. Ms. Wind, you may proceed with cross-examination.
Yes, Your Honor. Good afternoon, Ms. Cusack. I have a couple questions for you as well. First, while we don't dispute your qualifications to testify today, it is true that you are not a certified police officer, correct?
No, I am a certified crime scene reconstruction investigator.
So just to be clear, that means you haven't gone through law enforcement training or received law enforcement certification, right?
Objection, relevance. May I be heard?
I've got your objection on relevance. Ms. Wind, a response.
Your Honor, this witness's qualifications are certainly relevant. We just want to make absolutely clear that the jury understands what this witness is able to testify accurately in.
Your Honor, may I respond?
Mr. Wind, you may reply.
Your Honor, the defense or the prosecution has not tried to admit Ms. Kuzak in any sort of police qualifications. Therefore, it's not relevant whether or not she has these qualifications, as we're not attempting to admit her in that. We only attempted to admit, we only admitted her in crime scene reconstruction.
I will find that this testimony tends to prove something material to the defense and will therefore overrule the objection. You may proceed, Ms. Wind.
Yes, Your Honor. So just to be absolutely clear, Ms. Cusack, you have not received law enforcement training, right?
No, I have not. But as a crime scene reconstruction, I took sort of standard basic courses that involve stuff like that.
Now, we have also heard that you visited the crime scene after it had been processed and the body removed, right?
Yes.
I want to go over some of the evidence that the police don't have in this case that is sometimes discovered in criminal investigations. First, nobody actually saw the intruder, right? Because he or she was wearing heavy clothing and a mask, right?
Yes, it was seen in the videos, yes.
Second, nothing in this investigation shows anything about whether that clothing or mask was removed from my client, right?
No.
And third, we have no fingerprints recovered at the scene, right?
Well, yes, but that is only because, like you said, the intruder was wearing heavy clothes, which include gloves.
In addition to that, we don't even have any DNA evidence at the scene, right?
The only DNA recovered was for the victim.
And we have no eyewitnesses, of course, because the victim is deceased, right?
Yes.
Adding all of these up, there is no physical evidence at the scene connecting my client to this crime, is there?
There is, yes.
Ms. Cusack, you just testified that we have no eyewitnesses, we have found no fingerprints, we have no DNA evidence. So adding all of that up, there's no physical evidence connecting my client to this crime, right?
No, there is no evidence.
Let's discuss some of the theories that you made in your investigation. First, you theorized that there was a struggle between Mr. Brackman and the intruder based solely on some scuff marks by the back door and a broken plate, right?
Yes, there is clear evidence from struggle from the broken plate and scuff marks.
And as we just discussed, you theorized that Mr. Brackman struggled with the intruder, but isn't it true that the coroner's report in this case shows no other wounds to Mr. Brackman's body other than the fatal stab wound, no defensive wounds, right?
Well, as I said before, they were engaged in close contact to obtain the knife.
So just to be absolutely clear, Mr. Brackman has no defensive marks on his body, right?
No.
And, excuse me, what you have previously stated is that the victim and the intruder were close together, probably in a bear hug sort of position, when the intruder reached over and stabbed Mr. Brackman in the back shoulder area, right?
Yes, that is correct.
Could you quick demonstrate what that would have looked like to the jury?
It would be sort of, well, the intruder would have been able to grab the knife and reach over and stab over the shoulder.
And you theorize that Mr. Brackman was alerted to the intruder's presence based solely on the presence of a Ring device, right?
Yes, it is a Ring security camera, and security cameras are for alerting someone or a homeowner of any harm or danger. So yes.
But Mr. Brackman didn't go and lock his doors, did he?
No, because the intruder noticed that the front one was locked and went to the back.
You also theorized that Mr. Brackman was stabbed near the kitchen, proceeded to the front door where he pulled the knife out and dropped it there, right?
Yes, through the struggle.
And part of your support for this theory is that there were blood droplets leading from the kitchen to the front door, where there was admittedly a lot of blood on Mr. Brackman, on the knife, on the floor, on the walls, on the ceilings, right?
Yes, the man was stabbed.
Please turn to exhibits 4 and 5, which I believe my co-counsel will pull up for you. Give us 1 second.
Let's start with exhibit 4 before
Yes,
we
Your Honor.
proceed to the next exhibit. One at a time, please.
Yes, Your Honor. So exhibit 4 to start, if you would, co-counsel. All right, this exhibit shows Mr. Brackman laying in a pool of blood. And then if we continue on to exhibit 5, this exhibit shows a picture of a very bloody knife. You use these in your investigation, including trusting their accuracy, right, Ms. Cusack?
Yes.
And as we previously stated, your theory is that Mr. Brackman pulled the knife out of his own back, right?
Yes.
So if you could please take a look at exhibit 4 again. Despite all of the blood everywhere, do you see any blood at all on Mr. Brackman's, hands or wrists in exhibit 4?
No,
I believe
do
we are.
not see any, but that could be because the knife handle had been.
Okay, council has asked for a pause here. The
Can you hear
timekeepers need
me?
to stop the clock just to make sure we have the witness reconnect here. So we have a delay. So let's pause for a moment, make certain that we have the witness back on the screen. Stand by, Ms. Wind.
Can you hear me?
Yes, but hold on, we still have a delay. Perhaps, and I hate to do this, Ms. Wynn, but in order to proceed, can we have let's pause for a second. Do you wish to offer exhibits 4 and 5?
No, Your Honor, we were merely using them as a method for impeachment.
All right, so let us, not, if you don't mind, stop displaying the images to allow for perhaps a bit more bandwidth. And you may proceed with your inquiry, and once you start, we will resume the clocks.
Yes, Your Honor.
You may proceed.
Yes. So in exhibit 5, I'm not sure if you caught it or not, but in the picture of the bloody knife, there are no finger or hand prints in that picture. Is that correct?
That is correct.
And remembering that Mr. Brackman had just been fatally stabbed, could you show the jury how he would have been able to pull that large of a knife out of his own back without cutting himself, and certainly without getting any blood on his hands or wrists?
Well, with a firm grip on the handle of the knife to pull it out, I don't see why there would be any cuts on his hands.
So it is your testimony that there's no way, there's a way that he could have just not gotten any blood on his hands or on the knife, right?
Yes.
And you have also stated that because the knife was partially lodged in the victim's scapula, it would have been very hard to pull out, right?
Yes, it's a knife in a body.
Finally, Ms. Cusack, you gave an 8-page statement for this case, right?
Yes.
And that statement, in your own words, includes everything you know that could possibly be relevant to this case, right?
Of course, yes.
And yet nowhere in that statement do you give the opinion that Avery Becker committed this crime, do you?
No.
In fact, nowhere in the statement do you even mention Avery Becker's name, do you?
I was to reconstruct the murder.
But just to be absolutely clear, you don't mention Avery Becker's name, do you?
No.
I have no further questions.
Thank you, Ms. Wind. Pause for a moment, and we will have the prosecution redirect plaintiffs or prosecution witness 3. Stand by. Mr. Whitten, you may proceed with redirect.
Yes, Your Honor. Allow one moment while I adjust my camera. Ms. Kuzak, what was your job in today's case?
My job was to reconstruct the murder of Mackenzie Brackman.
And does your job include tracking down and finding suspects for the crime?
No, that is a detective's job.
Thank you, Your Honor. No further questions.
Thank you, Mr. Winton. We will pause for a moment and then does the prosecution rest? I'm asking that of Ms. Burton. Can you, as lead counsel, assure me that the prosecution has made the record it wishes to make?
Yes, Your Honor, the prosecution rests.
Very well, thank you. Moving on to the defense may call its first witness.
The defense calls Professor Blake Van Owen.
All right, Ms. Kidder, and for the defense, we have Mr. Winton again. You may proceed with your examination, Ms. Kidder.
Good afternoon. Please introduce yourself to the jury. Your Honor, it appears that we're having technical difficulties again with this witness's sound, if you would allow us a moment.
All right, pause the timers for a second. Let's make sure the witness is ready to go.
Logan, if you're having a hard time connecting to sound, you can go down to the mute at the bottom screen and click the up arrow, and you can switch to phone audio and it'll give you a number to call in. And then we can still see you and we can hear you on the phone.
Hello? Can you hear me now?
Yes, we've got you. So if you are, if you're all right, then we will, it's okay, Logan. We will proceed with direct examination by Ms. Kidder. So when you're ready, you may proceed.
Thank you for your grace, Your Honor. Good afternoon. Please introduce yourself to the jury.
My name is Blake Van Owen.
What do you do for a living?
I'm a college professor and a private investigator.
Please tell the jury about your education.
I have a bachelor's degree from the University of Colorado Boulder and a master's degree in criminal justice from Ashford University.
Tell us about your work history.
I began my career as a police officer with the City of Aurora, Colorado Police Department, right out of college. I was with Aurora for about a year, but I ultimately became a private investigator and college professor.
What do you teach?
I teach a course on police practices and social justice.
We will be offering you as an expert in this case. Do you have any experience testifying as an expert?
Oh yes, I've testified in over 100 cases in the federal courts of Colorado, Kansas, and Arizona, and in the state courts of Colorado, Wyoming, Nebraska, and New Mexico.
Each time you have been offered, has the court found that you are qualified to testify as an expert?
Yes, variously, in the fields of crime scene reconstruction, cell tower analysis, general police investigation tactics, as well as use of force, false arrests, police practices, and forensic evidence techniques.
Your Honor, the defense offers Professor Blake Van Owen as an expert witness in the fields of police practices and criminal investigations.
Mr. Winton, any inquiry, objection?
No objection on those grounds, Your Honor.
The witness will be admitted as an expert in the area of police practices and investigations. Is that right, Ms. Kidder?
Yes, Your Honor.
Very well, you may proceed.
Professor, what were you asked to do in this investigation?
I was asked to review the police reports, the crime scene reconstruction conducted by Kyle Cusack, the cell tower reports, and the exhibits prepared by Detective Markowitz. I was also asked to conduct my own investigation in this case.
Let's first discuss your review of what the police did. What are your professional opinions concerning their work?
In my professional opinion, the investigation was rushed. Important things were missed, and their decision to prosecute Miss Becker was wrong.
Do you have any examples of rushed police work?
Oh yes. For example, Cusack believed that Brackman and the intruder struggled, which resulted in the stabbing. But there really is no reliable evidence for this. For example, the prosecution relies on scuff marks on the floor, but there's no way to tell how those marks got there or how long they'd even been there.
Do you have any other issues with Ms. Cusack's theory?
Yes, I disagree with her theory that Mr. Brackman had surprised the intruder with a knife that they were carrying. It just seemed incredibly unlikely.
Do you have any other issues with that knife evidence?
Yes, for her theory to even work, because the knife was stabbed downwards, well, the intruder would have had to have been standing behind the victim. But it's very clear from the ring security footage that the intruder wasn't taller than Mr. Brackman, so this is an impossible theory.
What conclusion did that lead you to?
It is most likely that the intruder was taller than the victim because of the angle and depth of the wound for the police's theory to work. But in my professional opinion, I think that this was a planned attack and the intruder came from the behind.
Did the police rush to any more conclusions?
Yes, they believed that Mr. Brackman was alerted to the presence of an intruder because he received notifications from ring security footage cameras, but there's no way to tell if that actually happened, and those notifications can quite easily be turned off.
We've established that the police made unsupportable conclusions. Now let's talk about their decision to focus on Avery Becker in this investigation. Was that decision supported by the evidence they found?
Absolutely not.
Why do you say that?
I say this because, well, first of all, Miss Becker didn't have her phone, which was the leading evidence that the police used to locate her to the place of the crime. For example, because her cell phone pinged off towers that were not very far from where Mr. Brackman lived, that led them to the conclusion that Miss Becker was at their residence.
What do you mean?
Well, what I mean by that is cell phone data isn't even remotely like GPS information because cell phones are able to connect to multiple towers at once and they often don't connect to the nearest tower. Evidence that a cell phone is pinged off a tower is not evidence that any person was any particular place. Cell phone data isn't like GPS information.
Objection outside the witness's realm of expertise.
Response, Ms. Kidder.
Yes, Your Honor. We qualified this witness as an expert in criminal investigations. This day and age, cell phones are a crucial part of every single criminal investigation, and this falls soundly within her expertise.
Reply, Mr. Winton.
Your Honor, at no point did Ms. Kidder ask any questions for Ms. Van Owen to testify to any experience with cell phone data. She also didn't testify to any sort of training or expertise relating to cell phone data, and cell phone data is in itself its own category, separate from police investigations. Therefore, this does fall outside the scope of her expertise.
I am going to sustain the objection. The witness was qualified in areas of police practices and police investigations. I did hear some testimony during the foundation questions about some experience with cell phones, but the witness was not offered as an expert in those fields, and so I will sustain the objection.
Your Honor, I move to strike her answer to that last question.
Granted.
Professor Van Owen, do you deal with cell phones frequently during your own private investigations?
Oh, well, certainty. It's a standard part of my practice. I mean, I've been admitted as an expert in that field many times, and as a police officer, I was trained in those fields.
Your Honor, the defense offers Professor Blake Van Owen as an expert in cell tower analysis.
Mr. Winton, any inquiry, objection?
Your Honor, the witness has not testified to any specific knowledge or training in the field of cell phone investigations. Therefore, she does not have the bare minimum requirement to be admitted in that field.
Rule 702 says that a witness may be qualified as an expert based on knowledge, skill, experience, training, or education. I take those in the disjunctive, and there was sufficient evidence of experience testifying in the area of cell phone evidence. So I will overrule the objection, admit the expert as the witness as an expert in the field of cell phone. What is it again, Ms. Kidder?
Cell phone analysis and cell tower analysis.
Cell phone analysis and cell tower analysis. You may proceed.
You were talking about how Detective Markowitz's cell phone analysis was not reliable. Would you like to finish that answer?
Yes, well, I believe I was saying that it wasn't like GPS information because, well, cell phones, they ping off towers in up to a 7-mile radius. A cell phone may, for example, make 5 consecutive calls from the same location, yet link up to 5 different towers for those calls. That's why it's impossible to make the assumptions she was making.
Did you form any other conclusions concerning the cell tower analysis in this case?
Yes, I disagreed with Cusack's conclusion that the phone was traveling a particular route because the phone had been pinging off of those towers. Again, like I said before, this is an irresponsible way to make that kind of conclusion, just because, again, it's not like GPS information.
Did the police do anything else in this case that was irresponsible?
Yes, the police failed to investigate their prime suspect's alibi.
What was that alibi?
Well, the evidence shows that Miss Becker had lost her phone prior to the murder. She spent the entire day with her friend Miss Perkins looking for her device. If someone else had Miss Becker's phone and was carrying it the way the police believe it was carrying and traveling, well, someone else must have had her phone.
Why do you say that?
Well, I say this because this is going to be the testimony of both Miss Becker and Miss Perkins. Secondly, there are records of incredibly short calls and multiple unanswered texts in rapid succession indicating that they both were looking for this deactivated device.
Based off of that information, did you form any conclusions?
Yes, this most certainly was not Avery Becker. He was with Taylor Perkins all day. And in addition, they were never at Mr. Brackman's house.
Did the police rely on any other questionable evidence in their investigation?
Yes, the police accepted screenshots of a text conversation submitted to them by a teenager. The police didn't even take the time to authenticate those screenshots once they got them. nor did they even get access to the actual phone.
What would access to the actual phone have proven?
Well, Denver PD has a Celebrate system, which will download a phone's contents and show what happened. A step as simple as this would have at least proven the validity of those screenshots. But the police failed to do this.
We've established that the police relied on faulty evidence in accusing Avery Becker. Are there any other failures in their investigation?
Yes, the police failed to investigate Blair Rollins, another student at Colorado High School.
Who is Blair Rollins?
Well, as a peer and a person, he was represented, Mr. Brackman had represented Blair's father, Jonathan Rollins, in a court sentence. At the sentencing hearing, when Mr. Rollins was sent to prison for life, he yelled he was going to get revenge. Blair Rollins was present in the courtroom at that time.
Please turn to what has been marked as Exhibit 22. Do you recognize this exhibit?
Oh, yes. This is the audio recording from Jonathan Rollins' court proceeding.
How do you know?
I obtained this record previously, as it's a public record, during my investigation, and I've listened to it before.
Your Honor, the defense offers Exhibit 22 into evidence, and its authenticity has been stipulated to by the parties in this case.
Mr. Winton, first question, did we stipulate to the authenticity of this?
Yes, the authenticity of this has been stipulated.
All right, thank you. Any objection or inquiry with respect to this exhibit?
Yes, Your Honor, I would object to hearsay as pursuant to Rule 801, as this is an out-of-court statement being used to prove the truth of the matter asserted.
Ms. Kidder, response to the objection.
Yes, Your Honor. First, under Rule 8032, this is an excited utterance made by Jonathan Rollins. This was made directly after he found out that he was going to prison for life, and it is a threat towards Mr. Brackman. Furthermore, we are not offering this for the truth of the matter, but rather for the effect on the listener, that being the effect that caused Ms. Van Owen to form this conclusion over the course of her investigation.
Mr. Winton, a reply.
Yes, Your Honor, the prosecution must be using this for the truth of the matter asserted, as the truth of the matter asserted being that Mr. Rollins was upset and he was going to get back at them, being the backbone of Ms. Van Owen's conclusions. This is being used to prove the truth of the matter asserted.
I will find that counsel has represented that this is an excited utterance under 803 and will admit it on that basis, assuming that's the case when we hear the recording. If that turns out not to be the case, then I will instruct the jury accordingly. You may proceed, Ms. Kidder.
Permission to publish, Your Honor.
Permitted.
Are there any other reasons the police should have investigated Blair Rollins?
Ms. Kidder, I believe I couldn't hear the audio from the recording.
Oh, my apologies, Your Honor, if we could stop the clock while I figure that out.
It's still not working.
All right, let's pause the clock for a second just to make sure. We'll give this one more try, and then I will accept an offer of proof from Ms. Kidder with respect to its contents.
Thank you, Your
We
Honor.
can't get it to.
When you share the screen, make sure you're checking the box at the bottom that allows for video and sound. So unshare your screen and try it again. And there's 2 check boxes at the bottom when you try and share.
I'll get you back, Brackman, if it's the last thing I do.
Could you hear it that time, Ms. Van Owen?
Yes, I could.
Are there any other reasons you're aware of as to why the police should have investigated Blair Rollins?
Well, first of all, Blair Rollins had a much stronger motive against Mr. Brackman because of his vendetta with the court hearing. Secondly, Blair Rollins and Avery Becker have the same build and body shape.
Where is Blair Rollins now?
No one knows. I searched for them using all standard police investigation techniques and couldn't find them.
Finally, did you form a conclusion as to who killed Mackenzie Brackman?
The only thing we can conclude with absolute certainty is that this was not Miss Becker. Not only did the police fail in their investigation, but she has a verifiable and absolute alibi that wasn't even considered by the police.
Thank you, Professor. I have no further questions, Your Honor.
Thank you, Ms. Kidder. Let us pause for just a second for the jury to or the scoring judges to catch up. Mr. Winton, you may proceed with cross-examination of this witness.
Yes, Your Honor. Allow me one moment to adjust my camera. Ms. Van Owen, are you ready?
It appears we may have lost the witness. Ms. Kidder, can you check on that?
Ms. Van Owen, could you please turn your video and audio on for cross-examination? Thank you.
I still see a mic muted. Let's pause for just a second.
Can you hear me?
Stop the clock. Okay, yes, we can hear you. All right, Mr. Winton, you may proceed with cross-examination if the witness is ready.
Good evening, Ms. Van Owen. You talked a lot about your CDR expertise in this direct, didn't you?
Yes, I did.
However, you didn't mention any specific CDR training in your affidavit.
Well, that's true. I believe that my training through my police practices and experiences and just basic investigation, as well as the fact that I have testified in this.
I'm sorry, is that a yes to my question? Is that a yes to my question? You didn't put any specific training in your affidavit?
I believe, yes, that's true.
Now, you used to work for the Aurora Police Department, is that correct?
Yes, that is true.
However, you left because you injured a young woman of color.
Objection, Your Honor. Under Rule 403, the prejudicial value of this is substantially outweighs any probative value.
Mr. Winton, a response to the 403.
Your Honor, as pursuant to Rule 403, the prejudicial value must substantially outweigh the probative effect on the listener. The probative value of the jury understanding why Ms. Van Owen left the Aurora Police Department is substantially outweighs any risk of prejudice to the jury. This is also proper cross-examination to go to the quality and credibility of this witness.
Reply, Ms. Kidder.
Yes, Your Honor. May we constructively approach the bench?
I understand that bench trials are or bench conferences are discouraged. So in the interest of time, I will deny that request. Do you have a reply to the response to your objection?
Yes, Your Honor. We have no objection to why she left, but I believe opposing counsel mentioned that she injured a young woman of color. Those details have nothing to do with the actual event itself, and it is just there to incite rage in the jury.
I will find that the comment as to the characteristics of the person who was allegedly injured is unfairly prejudicial, that its danger of unfair prejudice outweighs its probative value and will strike any testimony with respect to the character or the traits of that person. But I will allow counsel to inquire into previous instances as to why the witness was excused or discharged from her former employment. So the objection is sustained in part and overruled in part.
Ms. Van Owen, You left the Aurora Police Department because you injured an individual on duty.
Yes, I was following police procedures and practices, and that was in my training, and unfortunately that did occur.
Objection,
I left on my own.
Your Honor, I would object that this witness is going far outside the scope of my question. It was a very simple yes or no question. You left because you injured an individual, and she has gone far outside the scope of this question.
Yes,
I will
I would
ask
say
the witness, hang on, the council has lodged an objection apparently to a narrative response to a specific question. I will urge that in the interest of time, the witness confine her answers to the questions asked, understanding that it depends on how the question is asked. So you may proceed.
Your Honor, I ask that the last bit of her testimony is stricken from the record.
Well, that's pretty hard to do, counsel. So how about you ask the question again, and let's see how the witness responds.
Yes, Your Honor. Ms. Van Owen, yes or no, you left the Aurora Police Department after you injured an individual. Is that correct?
yes, I did leave.
Since then, you've become a private investigator and a professor,
Yes,
and your job requires that you testify in court.
yes, that's true.
However, you have only ever testified on the side of the defense. Is that correct?
Yes, that's the nature of my job.
Now, you are also paid for the defense. You are also paid by the defense, excuse me, for your testimony in today's court. Is that correct?
Yes, just as much as the prosecution is being paid by their own government and
So
funding.
that's a yes to my question. You are being paid by the defense for your testimony.
Objection, Your Honor.
Yes,
Asked and answered.
I will overrule the objection. I don't believe the witness has responded to the question. You may proceed, Mr. Winton.
Yes or no, Ms. Van Owen, you are being paid for your testimony by the defense. Is that correct?
Yes, that's the nature of my job.
So let's move on and talk about some of the conclusions you came to in this case. I'd like to start with your idea of what happened at the beginning of the break-in. You claim that there's little evidence of a struggle.
Yes, I do believe I claim that.
And you believe this because there's no before and after of the crime scene, so it's difficult to tell whether or not there was a struggle.
Absolutely.
You are aware of Exhibit 9 in today's case?
Yes, I am aware.
And you are aware that Exhibit 9 is a broken plate?
Yes.
Now, it's reasonable to assume that if a person broke a plate, they'd clean it up relatively soon after they broke it. Is that correct?
I don't know Mr. Brackman's habits, so I don't know if I can answer to that.
You're saying that you cannot answer whether or not it's reasonable for a person to clean up a broken plate?
Well, I guess I could answer on that ground. Yes, I think it's reasonable that a person would clean up a broken plate.
Now, you never went to the scene of the crime, is that correct?
No, I did not.
But Ms. Kuzak and Detective Markowitz did.
I'm not completely sure if they did or did not complete an investigation at the scene of the crime.
You were present in court today?
Repeat that, please.
You were present in today's court, is that correct?
Yes.
So you heard Detective Markowitz and Ms. Kuzak both testify that they went to the scene of the crime?
I believe so, yes.
Now, let's move on to what you think happened when Mr. Brackman was stabbed. You believe that he was sitting down when he was stabbed, is that correct?
He was face down when he was stabbed?
No, you must have misunderstood me. He was sitting down, like in a chair.
Yes.
This would have mean that he would have been surprised. Is that correct?
I don't believe that it implies that, no.
You think he would have sat down if he noticed an intruder in his home?
I think he sat down before he noticed there was an intruder.
meaning he would have been surprised by the intruder.
I mean, after his presence was made known, yes, he probably was surprised.
Now, the back door leads directly into the kitchen, is that correct?
Yes.
Now, you never searched Mr. Brackman's phone?
No, I did not.
Now, you don't believe that you don't believe that Avery Becker committed this crime, is that correct?
I don't believe she committed this crime.
You believe that it was Blair Rollins?
Yes, that's my lead theory.
However, the only real evidence that you have for this is that Blair was not at school that day.
I guess you could say that, but I think his motive was a much stronger motive.
So that's a yes to my question. The only actual evidence you have is that Blair was not at school that day?
I guess you could say that.
Now, Ms. Becker and Ms. Perkins were also not at school that day, is that correct?
Yes.
Thank you, Your Honor. No further questions.
Thank you, Mr. Winton. Let's pause for just a moment before we get into redirect. All right, Ms. Kidder, your witness.
Your Honor, before I begin, may I request how much time I have left?
My timer reads 14 minutes and 4 seconds.
Thank you. Professor Van Owen, you were asked on cross-examination if you visited the crime scene. Why were you unable to visit the crime scene?
Well, the police wouldn't have allowed me, even if I tried. And in addition, well, that's not my job right now. The crime scene's cleaned up. I don't even know who lives there.
Thank you. No further questions, Your Honor.
Thank you, Ms. Kidder. The witness is excused. Let us pause for just a moment. And the defense may call its next witness. Counsel, if you light up your screens, unmute your mics. Same for the witness.
The defense calls Taylor Perkins, Your Honor.
Thank you, Mr. Stuckey. Taylor Perkins, step forward.
Good evening. Please introduce yourself to the jury.
Good evening. My name is Taylor Perkins.
Tell the jury a little bit about yourself, Miss Perkins.
Well, I'm a freshman at CU Boulder, and last year I graduated from Colorado High School.
Do you know Miss Becker?
Yes, I do.
How do you know her?
Well, Avery and I are best friends. We went to high school together, and before I graduated, we were both on Coach Brackman's mock trial team.
Did you see Mr. Brackman and Miss Becker interact?
Yes, mostly at mock trial practices.
In your perception, what was the relationship like between the two of them?
It was probably strained.
In what ways was it strained?
Well, Avery was the type of person who had natural talent, who didn't have to work hard to be good. She was the best attorney on the team, but also worked the least. I saw that really bothered Coach Brackman. She would come to practice late, was unprepared, and that made Coach Brackman really mad.
Do you have any examples of your coach getting mad?
Yes. About a month before the regional tournament, Avery came to practice the least prepared she had ever been, but she still did amazing in her closing argument. Coach Brackman got really upset and demoted her to the B team.
What happened on the mock trial team after that?
Well, about a week before the regional tournament, I resigned from the team because I thought that Coach Brackman had been unfair to Avery and to the entire team.
Was there any other reason that you stepped down?
Yes, mock trial was not that important to me anyway, and without Avery, it just wasn't fun anymore.
So did the team go to the regional tournament without you and without Miss Becker?
No, after I resigned, Coach Brackman put Avery back on the A team, which I thought might happen. And the team is fortunate I stepped down because Avery won Best Attorney and Best Closing Argument awards at the regionals.
Did Miss Becker then go to the state tournament with the team?
No, Coach Brackman kicked her off the team again after the regional tournament. but I wasn't there when it happened. Anyway, the state tournament was canceled because of this horrible virus.
When did you next see Miss Becker after she was kicked off the team again?
Well, a few days later, she came to my house and we hung out for a while. Then that night we went to the Fry Shack to get some food.
Did anything happen at the Fry Shack?
We saw most of the mock trial team there. Everyone was really friendly towards Avery and pretty upset Coach Brackman had kicked her off the team.
Did anything else happen while you two were there?
Oh yeah, Avery got really upset at something Alex Cifuentes said and stormed off to the restroom.
How did you know that she was upset?
Well, I could just tell. And she left her cell phone on the table.
Why was that unusual?
Well, just like most of my friends, Avery was pretty attached to her cell phone, so it was a little surprising that she left it there.
Did you pick up Miss Becker's phone when you saw it on the table?
No, I thought she would, but she didn't. We left in such a hurry.
So when did you realize that Miss Becker left without her phone?
Well, the next morning, when she was supposed to pick me up for school, she didn't respond to any of my texts.
Did you see her that day?
Yes, she came by and picked me up.
And what day was that?
It was March 6th, 2020, the same day that Coach Brackman died.
What happened once Miss Becker picked you up?
Well, I asked her why she wasn't responding to my texts. Just then we both realized she was missing her phone.
Did you do anything when you both realized that the phone was missing?
Well, we really needed to find her phone. So we decided to ditch school and retrace our steps from the previous day since we both had first period off.
Where exactly did you look?
Well, we went to the mall and checked each store we had gone into. When we couldn't find it in any of those places, I remembered her phone being on the table at the Fry Shack. So we went back and checked there.
Did you find it at the Fry Shack?
No.
Did you do anything else to try to find the phone?
Well, while we were still searching, I used my phone to try texting and calling Avery's phone several times.
On March 6, 2020, how long did you spend searching for Miss Becker's phone?
We burned the whole day looking for that phone.
So what happened after Miss Becker picked you up and you skipped school and you went to the mall and you went to the Fry Shack and you made all those calls and texts searching for the phone?
Well, while we were still at the Fry Shack, we saw a few of the mock trial team members there, which was pretty crazy.
Why do you say that?
Well, they should have been at practice, but Coach Brackman never showed up, and the team couldn't get a hold of him.
Ms. Perkins, from the moment Avery Becker picked you up early in the morning on March 6, 2020, until the time everyone left the Fry Shack, did Ms. Becker ever leave your presence?
No, never.
Did the two of you go to Mr. Brackman's house at any time?
No, never. We don't even know where he lives.
Did you see Mr. Brackman at any time on March 6, 2020?
Absolutely not.
Ms. Perkins, do you know someone named Blair Rollins?
Yes, Blair was a classmate at school.
Do you know of any connection that Blair Rollins had with Mr. Brackman?
Well, everyone at school knew that Blair Rollins was hateful towards Coach Brackman.
And why was Blair Rollins hateful towards Coach Brackman?
Because Coach Brackman lost a case that sent Blair Rollins' dad to prison for life.
Are you aware of any reputation that Blair Rollins had at Colorado High School?
Well, everyone at the school agreed that if there was one person who could kill somebody and not even think twice about it, it was Blair Rollins.
Ms. Perkins,
Speculation.
Ms. Burton, you have an objection. Repeat for me, please.
Speculation. This witness does not have the means or has not laid proper foundation to testify about the rest of her classmates' opinions on who could have murdered Mr. Brackman.
Mr. Stuckey, the objection appears to be lack of personal knowledge. A response.
Your Honor, this is not speculation, as Ms. Perkins was testifying about a reputation that Blair Rollins had at Colorado High School, and this is personal knowledge based on reputation. Further, under Rule 405A, reputation is a method of proving character, and we're using Blair Rollins' reputation for having a natural tendency towards violence to prove his character.
So I'm going to allow Ms. Burton to respond in just a second, but I believe the response is that this is being offered as reputation evidence of character of someone who is not a witness and not a party. Is that correct, Mr. Stuckey?
Yes, Your Honor, that's correct.
Ms. Burton, your reply to the response.
I do not believe that this witness had laid proper foundation to testify to the reputation at her school and that it is not relevant.
There appears to be a relevance objection as well. Mr. Stuckey, do you care to respond to that before I rule?
Your Honor, this is relevant because it is the defense's position that Avery Becker did not commit these crimes, but rather Blair Rollins. And this goes to prove that Blair Rollins committed this crime.
I'm going to find that the reputation evidence, although it can be used to prove some forms of character in a situation where such as this, because the person about whom the reputation is being offered is not a witness, is not the defendant, not a party to this case, I'm going to find that that objection will be sustained. On the issue of relevance, I find it is relevant, but I don't know that it can be proved in the manner in which counsel is offering it. So I will sustain the objection that with respect to character through reputation. You may proceed, Mr. Stuckey.
Ms. Perkins, I have just a few more questions for you. You know that Avery Becker is on trial for murder in this case. Have you ever experienced anything of a violent nature in Miss Becker?
Oh my gosh, no.
Do you have any reason to believe that she committed a burglary or a murder on March 6, 2020, or ever for that matter?
Have you ever seen Avery Becker? She's not even capable of those things. Absolutely not.
And finally, on March 6, 2020, after Ms. Becker picked you up early in the morning, was she ever out of your presence?
Not for 1 second.
Thank you. I have no further questions, Your Honor.
Thank you, Mr. Stuckey. We will pause for a moment and then allow Ms. Burton cross-examination. Ms. Burton, you may proceed.
Your Honor, before I begin, can you hear and see me all right?
I can, thank you.
Good afternoon, Ms. Perkins. You testified that Miss Becker and your former coach had a difficult relationship, correct?
Yes, I did testify that it was probably strained.
And this was because Mr. Brackman believed Miss Becker did not put enough time into mock trial, yes or no?
Yes, that's part of the reason as to why their relationship was strained.
Therefore, her lack of time spent on mock trial most likely affected the team, correct?
No, I actually believe that she had enough natural talent to make up for her lack of effort.
Moving on, you also previously stated that Miss Becker was kicked off the team after an incident with your coach's car, yes or no?
Well, I wasn't there, so I can't testify about the car. I do know she was kicked off the team, so yes.
However, you did previously mention that Miss Becker could be rash. Is that correct?
Well, there are times that she can be. What teenage girl isn't sometimes?
So you believe Miss Becker being kicked off the team was a punishment for her vandalization and rash decision?
Well, again, I wasn't there, so I don't know the reasons as to why she was really kicked off the team.
Moving on, you mentioned that Miss Cifuentes and Miss Becker were not the closest of friends, correct?
Objection, Your Honor. Speculation.
Your response, Ms. Burton.
Your Honor, this is not speculation pursuant to Rule 701. This is proper lay witness testimony rationally based on the witness's perceptions and observations.
Reply, Mr. Stuckey.
Your Honor, the witness has not testified to any observations of the relationship between Ms. Cifuentes and Ms. Becker, and there's not been foundation for the witness to answer this question.
Well, that is what speculation is about. Ms. Burton, if you are able to lay further foundation, I will allow you some time to do that. Otherwise, I am inclined to sustain the objection.
Ms. Perkins, You did know that Miss Becker planned on contacting Miss Cifuentes, correct?
No, I didn't know that, and I don't believe that she did.
Your Honor, at this time, I ask that our trial technician please pull up Exhibit 17, which has previously been admitted into evidence.
You may.
One moment.
Ms. Perkins, you've previously been interviewed by Kyle Kuzak, correct?
Yes, she did previously interview me.
Now, on this tracking sheet in the right top hand corner, it states that you described the text exchange with suspect 1 labeled as Alex Cifuentes and Miss Becker, correct?
Yes, it is labeled that way, but there's no proof that it genuinely was from Avery.
However, you did describe this in your interview?
Objection, Your Honor. Asked and answered.
Overruled. You may continue, counsel.
In your interview, you did testify to your knowledge of the text exchange, yes or no?
Again, these screenshots do appear to be from Avery, but there's no proof. They could have easily been doctored.
Your Honor, I have asked a properly worded yes or no answer, and the witness is unresponsive.
Counsel, I am not inclined to rescue you, but you may persist if you feel the witness is not responding to your cross-examination.
Is that a yes or no to my question, Ms. Perkins?
Well, this is my third time answering it. Yes, technically it was, technically it does appear to be from Avery, but there's no proof behind that. It wasn't from her. She would never send those messages.
You must have misunderstood me. I was asking a yes or no question about that you did testify to the text messages between Ms. Cifuentes and Ms. Perkins.
Are you talking about on my director, specifically in the exhibit number 17? Maybe I'm unclear on what you mean.
In Exhibit 17.
Okay, well, again, in that, I didn't testify to them. I testified to what they appear to be.
Moving on, you were interviewed by Kyle Kuzak about the whereabouts of Miss Becker on the day the murder took place, correct?
Yes, I have previously been interviewed by Kyle Kuzak.
And this was because you and Miss Becker skipped school on March 6, 2020?
Yes, we skipped it to search for her missing phone.
During your interview, you also testified to the distance between Miss Becker and the victim's house, correct?
Yes, I did.
And this was because you claim to have been with Miss Becker the entire day the murder took place?
Yes, I was with her the entire day.
However, you and Miss Becker both had first period off, and that's why you rode together, correct?
Yes.
Therefore, you cannot actually account for Miss Becker's whereabouts in the morning before she picked you up for school, yes or no?
Well, I suppose not, but Coach Backman wasn't murdered in the morning.
However, you were not actually with Miss Becker all day, yes or no?
Well, I suppose if you're really going to get on a technicality with me, the 24 hours, no, and I wasn't with her when she was sleeping, so I suppose not. But when she picked me up in the morning, I was with her every minute after that.
To their best of your knowledge, would it be accurate to say Miss Becker felt angry and disappointed about being kicked off the team?
Well, yes, anybody would be after 4 years of hard work.
And you previously stated that you felt your coach's decision was unfair, correct?
Oh, absolutely. It was very unfair.
So, to the best of your knowledge, it would be accurate to say that Miss Becker also felt that your coach's decision was unfair, yes or no?
Objection, Your Honor. Speculation. The feelings of Miss Becker towards Mr. Brackman's decision are speculation.
Ms. Burton, a response.
Your Honor, I have properly worded this question to be based on Ms. Perkins' best observations and to the best of her knowledge.
Mr. Stuckey, a reply.
Your Honor, I believe that the witness can testify about Ms. Becker's reaction to being kicked off the team, but not to how she felt about the decision. I believe that that is speculation.
I will overrule the objection and find that the question is properly framed and is that an adequate foundation has been laid for the question anyway.
Ms. Perkins, would you like me to re-ask the question?
Yes, please do.
Would it be accurate to say, to the best of your knowledge, that Ms. Becker also felt that your coach's decision was unfair?
Of course, he didn't have any real reason to kick her off.
Therefore, Ms. Becker, to the best of your knowledge, had many mixed emotions about your coach after his decision to remove her from the team. Yes or no?
I suppose so. I don't really know how to testify to her emotions.
However, Ms. Becker's previous rash decision was also when she had many mixed emotions about your coach's disapproval of her work ethic, correct?
Sorry, could you rephrase that question? I don't completely understand.
When Ms. Becker previously vandalized her car, it was due to her mixed emotions about your coach's disapproval of her work ethic after your regional competition, correct?
Objection, Your Honor, hearsay and lack of foundation.
A response, Ms. Burton?
Your Honor, based on the hearsay objection, this is not hearsay pursuant to Rule 801D2, as it is a statement of a party opponent.
Mr. Stuckey, a brief reply.
Your Honor, the witness is not being asked to testify about something that Ms. Becker said, but rather the incident involving Mr. Brackman's car. And the witness was not there for this event, and this calls for hearsay.
Okay, I am going to overrule the objection on the basis of hearsay because I think counsel has just admitted that the question did not ask for a statement or a declaration. The question asked about the coincidence of rash behavior and a previous interaction between the victim and the accused. So I will overrule the objection. You may proceed, Ms. Burton.
Yes, Your Honor. Ms. Perkins, would you like me to re-ask the question?
Yes, please.
Ms. Becker's previous decision when she vandalized your coach's car was also when she had many mixed emotions about your coach's disapproval of her work ethic, correct?
I don't think I'm in the correct place to testify to that, as I wasn't there when it happened, and therefore I don't even know what she was feeling or thinking.
Ms. Perkins, do you believe Ms. Becker's mixed emotions about your coach's decision to remove her from the team could have caused her to make a rash decision like the former car vandalization?
I mean, I could, but I'd be speculating about what she was thinking and feeling.
Thank you. No further questions.
Thank you, Ms. Burton. We will pause for a moment before redirect. Mr. Stuckey, you may proceed with redirect.
Your Honor, may I inquire as to how much time we have left for direct examinations?
You have 7 minutes and 29 seconds remaining.
Your Honor, on that, I have no redirect examination.
Thank you, Mr. Stuckey. The witness may step down and the defense may call its next witness.
The defense calls Avery Becker.
It appears the witness is in the chair. Counsel is where they belong. So Ms. Wind, you may proceed.
Yes, Your Honor. Good evening. Please introduce yourself to the jury.
My name is Avery Becker.
Miss Becker, we have heard you on trial today concerning the death of Mackenzie Brackman. Did you know Mr. Brackman?
Yes, I did know him.
How did you know him?
He was my high school mock trial coach.
And where did you go to school?
I attended Colorado High School.
Do you still go to school there?
No, I graduated last year.
How long were you on the Colorado High School mock trial team?
Oh, all 4 years of high school.
Was Mr. Brackman your coach for all 4 years?
Yes, it was.
What kind of roles did you play on the team?
For several years, I played the role of an attorney.
How would you describe your relationship with Mr. Brackman?
Well, I would say it was strained.
In what way?
Well, you see, mock trial just came quite naturally to me. I worked hard, but never hard enough for Mr. Brackman. I admit I didn't always prepare as much as he wanted me to, and I didn't always focus at practice, but I thought I could do well enough without too much practice, just because it came so naturally to me.
Did you ever receive any recognition for your success at mock trial?
Yes, I won the Best Attorney Award at the regional tournament last year.
Ms. Becker, you said you did not work hard enough for Mr. Brackman. What do you base that on?
Oh, Mr. Brackman was a very demanding coach and required a lot out of everyone on the team. I probably didn't work hard enough for his high standards, and he would certainly criticize that.
Were you the only person on the team he treated like that?
No, Mr. Brackman was hard on everyone. He was never good at handing out compliments, and he would get on all of us, really.
Objection, Your Honor. Improper character evidence.
Your response, Ms. Wind.
Your Honor, this witness is simply testifying to what she had observed in her course as a part of the mock trial team. I don't see how this is improper character evidence.
Mr. Hernandez, reply.
Your Honor, in pursuant to Rule 404A, Ms. Becker is attempting to speak to the character of Mr. Brackman as one who did not hand out many compliments and as such is speaking to his character.
I will find that it is evidence of character and is inadmissible. I will sustain the objection. You may proceed, Ms. Wind.
Ms. Becker, do you remember any specific instances of conflict between you and Mr. Brackman?
Yes, there was a practice about a month before the regional tournament. I went to practice as usual, but Mr. Brackman was particularly hard on me. I started to respond, and Mr. Brackman just snapped. He demoted me to the B team, and he also changed my roles.
Then what happened?
Well, I know this was wrong, but I argued with him and I told him he was a terrible coach. I regretted it, but I privately boasted that if it weren't for me and a few others on the A team, we wouldn't have placed in regionals because I thought I deserved to be on the A team because of the awards I had won.
Did you ever get back on the A team?
Yes. My friend Taylor Perkins is on the A team and she quit. That's caused Mr. Brackman to put me back onto the A team. Excuse me.
Good. Did you go to regionals?
Yes, and like I said, I won the Best Attorney Award, and I also won the award for the Best Closing Argument of the whole regional tournament.
Did that make Mr. Brackman happy?
No, he was upset that I had ad-libbed some of my closing and that it didn't follow the script he wrote. He also said it didn't deserve the Best Attorney Award and that it was just lucky. Told me I wouldn't even do well at the state competition.
Then what happened?
Well, I argued with him and I boasted that if it weren't for me, we wouldn't have even placed in regionals.
What did you do after that?
Well, I know this was wrong, but I left practice and I did the stupidest thing of my life.
What did you do?
I had a marker in my hand when I left practice. I thought it was a dry erase marker. Mr. Brackman had this Porsche car and I wrote Worst Attorney Award right on the hood of his car.
Did you see Mr. Brackman after you did that?
Yes, he walked up behind me after I finished and he saw what I had done.
How did he respond?
Oh, he said lots of things, but the one that was the hardest was that I was off the team.
What did you do after that?
I just went home after that and I talked about the incident with my mom and she suggested I go and apologise in the morning and I knew that was the right thing to do. I was still so upset. I told my mom I would get back at Mr. Brackman as I was crying so.
Did you go and apologise?
Well, I tried. I went to his office the next day and asked his secretary if I could see him.
Were you able to see Mr. Brackman?
No, he didn't want to talk to me. And I really wanted to apologize in person, but I realized I wasn't going to be able to do that.
Did you do anything else to express regret?
Yes, I texted him saying how sorry I was. I told him I would work to fix the paint on his car as well.
Ms. Becker, I know this is going to be difficult for you, but let's talk about the day in question, March 6, 2020. Can you tell the jury what you did that day?
Yes, though I would have to start the day before. On March 5th, I'd gone to the mall in the Fry Shack with Taylor Perkins, and I think I actually left my phone there. So the first thing I did on March 6th was go to look for my cell phone.
Did you find your phone?
No, and we spent all day looking for it at the mall in the Fry Shack, and we couldn't find it.
Did you ever find your phone?
No, I must have left it at the Fry Shack, and the only other person near it was Alex Cifuentes.
What was your relationship with Miss Cifuentes like?
Oh, Alex and I weren't even friends. Also, Alex didn't want me back on the team because Alex wanted to be the best attorney.
Speculation.
The objection appears to be lack of personal knowledge. Ms. Wind, a response?
Yes, Your Honor. As Ms. Becker just testified, she and Alex Cifuentes were both on the mock trial team together. They had plenty of time to interact with one another and get to know each other. So Ms. Becker is perfectly within the realm of reason to testify about what she observed of Alex Cifuentes.
Mr. Hernandez, reply?
Your Honor, I would argue that Ms. Becker is forming an opinion that is not rationally based on her perceptions and observations.
I did not hear a sufficient foundation and will sustain the objection for that reason. You may proceed, Ms. Wind.
Yes, Your Honor. Ms. Becker, you have heard the testimony of Alex Cifuentes today, claiming to have received a text from you admitting you were going to commit crime. How do you respond to that testimony?
Well, I didn't even have my phone, and I never texted Alex Cifuentes. That was a lie.
Ms. Becker, the prosecution today claims that you had a motive to retaliate against Mr. Brockman. You have said you have no such motive. Do you know of anyone outside of the mock trial team who had a reputation of conflict with Mr. Brockman?
Objection,
Yes.
Your Honor, calls for speculation and improper character evidence.
All right, the question appears to be based on reputation. I agree that an inadequate foundation, that it is speculation at this point. Ms. Wind, if you do wish to lay a better foundation as to the reputation evidence, I'll allow for that and we'll see where it takes us. The objection is sustained for now.
Yes, Your Honor.
Ms. Becker, did you know Blair Rollins?
Yes, I did. He was a classmate of ours at Colorado High School.
And why do you say that Blair Rollins had a reputation for conflict with Mr. Brockman?
Oh, it was well known at school that Blair hated Mr. Brockman. Mr. Brockman was a criminal defense lawyer, and he lost a case that got Blair's father sent to prison.
Is there any other connection Blair Rollins has to the events of March 6, 2020 that you are aware of?
Yes, Blair was good friends with Alex.
Now, Ms. Becker, I have to ask you this because of what the prosecution has charged. Did you break into Mr. Brockman's house on March 6, 2020?
No, ma'am. I didn't even know where he lived.
Did you go to Mr. Brockman's house on March 6, 2020?
Absolutely not. Again, I didn't know where he lived, and I was with Taylor all day.
Did you ever text anyone that you would get back at Mr. Brockman?
No, ma'am. I had lost my phone on March 5th, the day before. I couldn't have texted anyone on March 6th.
Miss Becker, did you kill Mr. Brockman?
No, I would never do anything like that to anyone. I mean, we might not have gotten along, but I would never even think of harming anyone, no matter what the reason.
Thank you, Miss Becker. I have no further questions, Your Honor.
Thank you, Ms. Wind. We will pause for a moment and then allow Mr. Hernandez an opportunity for cross. Mr. Hernandez, you may proceed.
Yes, Your Honor. Ms. Becker, in your opinion, you were one of, if not the best competitor on your mock trial team, correct?
Well, I suppose I would say I was pretty good at mock trial. Yes, it came naturally to me.
You felt that mock trial came naturally to you and that you had little need to put a lot of effort into your work. Isn't that right?
I didn't always practice as much as Mr. Brackman wanted me to, but he was able to do it pretty well and naturally.
And the victim did not share this opinion with you, did he?
We didn't always agree on matters of mock trial, no.
In fact, your relationship got to the point that you felt it right to vandalize a vehicle that he obviously cared for, correct?
It was the stupidest thing I've ever done. I immediately regretted it.
So that's a yes to my question.
I shouldn't have done that, no.
And Miss Becker, you vandalized his vehicle with a permanent marker, correct?
At the time, I thought it was a dry erase marker, but like I said, I immediately regretted it.
But it was a permanent marker, yes or no?
Unfortunately, it was, yes.
And from that moment, Mr. Brackman kicked you off the CHS mock trial team, correct?
Yes, he did.
And the reason that you vandalized his vehicle was because the two of you had just entered one of your strongest and most heated arguments yet. Isn't that right?
We had disagreed at practice that evening, and I did leave rather upset, and he did mess up his car, unfortunately.
But despite this argument getting quite heated, the victim walked out into the parking lot, apologized to you, and invited you back into practice, didn't he?
He did, and I so regretted what I did to his car. I felt horrible.
So we can agree that the relationship between you and Mackenzie Brackman was rocky, to say the least.
It was strained, yes. We didn't always agree.
And later, when the victim had kicked you off the CHS mock trial team, you texted Alex Fuentes for help, correct?
No, I never texted Alex Fuentes. We weren't even friends.
Ms. Becker, you were here for the deposition of Detective Jordan Markowitz, correct?
Yes, I was.
And you heard him state that when you tried to get back on the mock trial team and failed, you texted Alex Fuentes for help.
Sorry, but I never did that. I never would ask Alex for help on anything.
But you did hear Detective Markowitz speak to that matter.
I didn't text Alex, no.
Objection, Your Honor, non-responsive. I've asked Ms. Becker to speak to the fact that she heard Detective Jordan Markowitz say that she heard that, to speak to the fact that Ms. Becker spoke to Ms. Fuentes, according to Detective Jordan Markowitz.
I understand you're objecting, but I won't rescue you either, Mr. Hernandez. If you feel you need to dig deeper into your questioning, you may do so.
Yes, Your Honor. Ms. Becker, you heard Detective Jordan Markowitz say that when you texted Alex Fuentes for help and failed, that when you texted Mr. Brackman and failed, you reached out to Missy Fuentes for help getting back on the CHS mock trial team, correct?
Alex may claim that I did, but I never texted Alex.
Your Honor, at this time, I ask that my trial technician display what has been previously marked as Exhibit 14.
You may.
Objection, Your Honor, improper impeachment.
I don't believe counsel is offering this for impeachment. I will withhold judgment on your objection for the time being. I believe the request was to display an exhibit that had been previously admitted. So let's do that and we'll see where this takes us.
Ms. Becker, in this conversation that Missy Fuentes has testified under oath that the two of you had, the Avery Becker of this conversation says, "I'm pretty desperate to get back on. Is there any way you'd be willing to talk to Coach Brackman about having me back, correct?"
Sorry, but I've never seen this exhibit before, ever. I didn't text any of this. I don't know what this is.
But Missy Fuentes, if you read this statement, it does in fact say that
Objection, Your Honor, asked and answered. This witness just testified that she had no knowledge of this exhibit, and therefore she has already answered council's question.
I believe I can resolve this. Council has asked, is attempting to use this statement now that he is trying to attribute to this witness, and in using it as a form of impeachment. And in order to impeach a witness, the witness must first be given an opportunity to acknowledge the statement as hers. And I believe this witness has denied consistently that this statement is hers, and therefore impeachment using this statement is improper. So I will sustain the objection and ask council to move on.
Yes, Your Honor. Ms. Becker, moving to the date of March 6, 2020, the day of the victim's murder. You say that you're with Miss Taylor Perkins looking for your missing phone, correct?
I was with Taylor all day that day, yes.
This being the phone that Detective Markowitz placed at the scene of the crime within 2 hours from when the body was reported, correct?
I don't know what the detective said. I'm sorry, I don't know what you're asking.
Ms. Becker.
And hold on a second. May we have the screen sharing discontinued and so that we can proceed with full visibility?
Yes, Your Honor. Ms. Mintz? Thank you.
Thank you.
Again, Ms. Becker, moving to the date of March 6th, you have stated that you spent that day looking for your missing phone with Miss Taylor Perkins, correct?
That's correct, yes.
And this being the phone that Detective Markowitz placed at the scene of the crime within 2 hours from when the body was reported, correct?
Objection, Your Honor, beyond the scope. The witness has no knowledge to answer this question.
Overruled. Cross-examination can exceed the scope.
Ms. Becker?
I'm sorry, I still don't quite know what you're asking. I don't know what the detective said. I lost my phone.
Again, you were here for Detective Markowitz's testimony, correct?
I heard what she had to say, yes.
Exactly. And you heard her state that she found your phone within 2 hours from when the body was reported near the scene of the crime, correct?
Well, Alex must have taken my phone when I was at the fry shack, so Alex could have had my phone with Blair Rollins, I suppose.
To explain the fact that Miss Detective Jordan Markowitz found your phone near the scene of the crime, you state that Alex Fuentes and Blair Rollins might have stolen your phone, correct?
That must have been what happened, because I didn't have my phone. Last place I saw it was with Alex at the fry shack.
But half the basis for this belief is because Blair Rollins had the same build as you, yes or no?
That's not the way I think that, but I mean, yes, Blair does look like me, kinda, yes.
And the other half of this belief is because Alex Fuentes had the same, it was because Alex Fuentes was jealous of you, correct?
Time.
Your Honor, my
Time has expired, counsel.
Yes, Your Honor.
Redirect by Ms. Wind. Let's pause for just a second, and then we'll have redirect of this witness by Ms. Wind. Ms. Wind, you may proceed.
Yes, Your Honor. Before I begin, may I ask for a quick time check?
You have 19 seconds remaining.
Okay, thank you. All right, Ms. Becker, did you kill Mr. Brackman?
Absolutely not. I would never hurt anyone, ever.
Thank you. I have no further questions, Your Honor.
Thank you. The witness is excused. Ms. Wind, does the defense rest?
Yes, Your Honor, the defense rests.
That concludes the evidence. Let's pause for just a moment, allow counsel to compose themselves, and then we will proceed to closing argument. All right, according to my notes, Mr. Hernandez, you are offering the prosecution's closing argument. You may proceed when you're ready.
Yes, Your Honor. Before I begin, can you see and hear me okay?
Yes, sir.
Good. Again, should any of those conditions change throughout my closing statement, please do not hesitate to let me know.
I will.
May it please the court.
You may proceed.
A knife in the back. Members of the jury, Mackenzie Brackman was found just outside his door in a pool of blood with a knife wound in the back. Mackenzie Brackman was a dedicated member of society. He made movements to bring justice to those who needed it and put forth extra time and effort to teach young adults the very practice that can save many from unjust punishments. But because he was willing to put in the strokes to improve the obvious talent in a young pupil, he was made the victim of a cruel and devastating murder with a knife in the back. A history of conflict has been made clear between the defendant and the victim. They had argued in almost every one of their practices, and when the victim had deemed it appropriate that the defendant be removed from the CHS mock trial team, the defendant acted out and wrote Worst Attorney Award across the hood of the victim's precious 1986 Porsche vehicle, and she did so with a permanent marker. Today you heard from Ms. Alex Cifuentes, who spoke to the rigid and aggressive relationship between the defendant, Avery Becker, and the victim, Mackenzie Brackman. You heard from Ms. Kyle Kuzak, who was able to illustrate the scene of the crime in vivid pictures and how that same crime scene correlated to a trashing that the defendant, had mentioned in a stream of text messages with Alex Cifuentes. And furthermore, you heard from Detective Jordan Markowitz, who started this hearing with a stream of strongly supported evidence that points to one, Avery Becker. The prosecution holds the burden of proof in today's case. We must prove to you beyond a reasonable doubt that Ms. Becker committed second-degree burglary of a dwelling and murder in the first degree. Now, a reasonable doubt is a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence. If you find that all pieces of evidence and each element of the crime has been proven, then you must find the defendant guilty of such crimes. Members of the jury, today my co-counsel introduced ourselves by saying that we would prove Ms. Becker committed both murder in the first degree and second-degree burglary of a dwelling. With the testimony given in these past few hours, we have met that burden. With the testimony given in these past few hours, we have proven that the defendant was left alone in a pool of blood with a knife in the back. This betrayal was brought on by a single person. That one person is Avery Becker. Vote in the name of justice. Find the defendant guilty.
Thank you, Mr. Hernandez. Pause for just a moment and then allow the defense an opportunity for closing statement. According to my notes, that will be Ms. Wind. Ms. Wind, when you're ready, fire up your camera, fire up your microphone, and you may proceed.
Yes, Your Honor. All right. May I proceed, Your Honor?
You may.
Don't judge a book by its cover. That's what we have asked of you today, members of the jury. And when you review the evidence of this case, you must conclude that the prosecution's cover has nothing to do with the contents. A criminal prosecution is supposed to be based on fact, but today the people are trying to sell you pure Fiction. Don't buy it. They have failed in every respect to prove the guilt of our client. And why? Because Avery Becker didn't kill anyone. Good evening, members of the jury. My name is Clara Ann Wind, and for the next couple of minutes, I will be reviewing the evidence to show you how the prosecution has failed miserably to prove beyond a reasonable doubt that Avery Becker committed the crimes of second-degree burglary and first-degree murder. First, the elements of second-degree burglary. According to jury instruction number 8, the prosecution must prove that Avery Becker knowingly entered into Mackenzie Brackman's house with the intent to commit the crime of criminal mischief. They did not prove this. The evidence showed that Avery Becker had never even been to Mackenzie Brackman's house. And that certainly was not our client you saw in the videos today. There was no evidence to connect our client to the scene of the crime. All you heard that was many days earlier in an act of foolishness, Miss Becker did draw on Mr. Brackman's car. But that is a far cry from breaking into his house. Next, the elements of first-degree murder require the government to prove that Avery Becker committed second-degree burglary and killed Mr. Brackman during that burglary. They didn't prove this either. Not only had Avery Becker never been to Mr. Brackman's house ever, and certainly not on March 6, 2020, the evidence showed she was with Taylor Perkins the entire day. Avery Becker killed no one. She couldn't possibly have. The only thing Avery Becker is guilty of is an immature response to an argument she had with Mr. Brackman. Miss Becker acted out immediately after the argument, took what she thought was a dry erase marker, and drew on Mr. Brackman's car. But getting dismissed from a high school mock trial team is absolutely no motive to kill the coach. It is a wildly absurd theory from an investigation that never even looked into anyone else. Consider what this investigation relied on. Text messages that could have easily been faked from someone with a grudge against Miss Becker. The incredibly average size of a disguised figure in the video that could have been anyone except Miss Becker. And unreliable cell phone data from a phone Miss Becker didn't even have with her. More fiction from this misleading book. The prosecution has made numerous assumptions about what happened that day. They assumed the intruder didn't know Mr. Brackman would be there. They assumed the intruder used a knife from inside the house. They assumed there was a struggle. They assumed it was our client because they assumed her phone was somewhere within miles of the Brackman home. But under the law, a prosecution for murder has to be based on evidence beyond a reasonable doubt, not assumptions. Assumptions do not carry the burden of proof. Consider the testimony of Miss Van Owen. She testified that a student named Blair Rollins had real motive to hurt Mr. Brackman. But did the police investigate Rollins? No. Miss Van Owen established that the police conducted a superficial investigation and never sought to find a real killer. They took a student who had problems with her coach and asked you to look at the cover, but not the contents. The contents have no substance. They are an absolute fairy tale. Members of the jury, let's call this case what it is. Simply a book with a deceiving cover that promises you answers but leaves you with only questions. The prosecution's case today has left you scratching your head and wondering who could have possibly committed this crime because it wasn't Avery Becker. According to jury instructions number 1 and 2, the defense has to prove nothing. It's the prosecution which has the burden of proof. The prosecution has not met that burden. If you have any reasonable doubt about who committed this crime, the prosecution has not met their burden, and you must find Avery Becker not guilty. And that is exactly what we are asking you to do today, members of the jury. Find Avery Becker not guilty and send a message to criminal investigations that they need to go out and find the person who actually committed this crime so that justice can be done for Mackenzie Brackman. Thank you.
Thank you, Ms. Wind. The case will stand submitted. Let us pause for a moment and allow the scoring panelists to complete their score sheets and submit them. I need to wait until the courtroom monitor confirms that that's done, and then we will proceed to a brief after chat. For right now, I would ask that everyone just relax and take a deep breath. Stand by.
Your Honor, I believe that the prosecution was permitted a 1 minute and 35-second rebuttal argument.
Your Honor, I was under the same impression.
Mr. Hernandez, the rule requires that you request to reserve time for rebuttal, and you did not do that. I made note of that. So the failure to do that under the rules of the competition prohibits you from using unused time in rebuttal. You must reserve it up front. So the request is denied.
Yes, Your Honor.
So all of these score sheets have been submitted at this time.
Thank you, Ashley. All right, the first thing I want to say is that this has been a really good round. I'd like to hear from the scoring panelists briefly before you hear a bit from me. But I do want to thank you for the amount of work, obviously, that you put into this. So let me start on my screen. I have Joanne Mirando. Are you a scorer? Or I believe you are. So help me out here, and maybe 30 seconds to 1 minute of comments about the performance.
Okay, great. My name is Joanne Mirando, and I am currently an attorney at a family law firm. Prior to practicing family law, I was a criminal prosecutor, so a deputy district attorney for several years. So I have a lot of courtroom experience, you could say, good and bad. I've made a lot of mistakes, and you guys are great. I mean, every single one of you did such a great job. I'm so impressed. A few constructive criticisms. I guess the number one overall thing that I would say is it's really easy to get in your own outline. You've memorized your questions, you know the case, but listening to the witnesses' responses and trying to adjust depending on what they say is very effective. A couple examples that I have, the cross-examination of the detective. The detective kept saying there wasn't enough evidence for that. And a good response to that could be, you're the lead detective. You're the one that collects the evidence. You're telling me there's not enough, you know, kind of getting into that, even though it's not on your outline. If she's giving you those nuggets, kind of trying to hone in on those. And another one also for the detective, for the direct examination, the detective said, I had a great break at some point in the case. And I was thinking, oh, what is it? Well, what was the great break? But instead the direct examiner just kind of moved on from the point. So really trying to listen to the words that your witnesses are saying can be effective. Similarly, this is another thing about listening very closely. If you're going to ask a negative question, so this was a cross-examination about defensive wounds, and someone said, there were no defensive wounds, right? And then the witness said, no. And does that mean there are no defensive wounds, or does that mean there are defensive wounds? So if you're asking a negative question, you want to be extremely clear. The victim did not have any defensive wounds. Is that correct? And then the witness says, yes, that's correct, or no, that's not correct. So everyone's completely clear on what the answer is. And then my other comment, goes to difficult witnesses, it's kind of in the same vein. If you have a witness that is being so difficult, I mean, they're not giving you an answer that seems obvious or seems clear, try to get out of your outline and adapt to them, what they're saying. One example of this was one of the witnesses just refused to admit that the defendant was angry when she wrote on the car, or frustrated, or whatever the term was. And a way to kind of address that would be, so your position is she was happy when she took the permanent marker to the Porsche? Because the witness is being so difficult with you. I'm not a fan of being snarky with witnesses. The attorney always has to take the high road, but you can politely point out how difficult they're being. And I think that hits home with a lot of jurors. Similarly, the defendant was being difficult about knowing what the detective testified to. And a way to politely point that out is to say, you're on trial for murder here. We just had this witness testify to the evidence against you, and kind of make it seem like this witness really isn't cooperating on purpose. But overall, like I said,
Ms. Mirando, it was, I want to make sure we leave enough time for the others. Let me pull up my next scoring panelist, Ms. Mupani, is that correct? You're muted. You're muted.
Oh, there you go. Can you hear me now?
30, 60 seconds. Thank you.
Yeah, absolutely. It'll be 10 seconds. I really enjoyed it, you guys. Like, I thought this was really, really fun to watch. It reminded me of my time in high school, and I really enjoyed it. I thought you all did great. So good job.
Thank you. My third scoring panelist, Ms. Henson, is that right?
Yeah, Alex Henson. So I really enjoyed, I did the tournament a few weeks ago, and I've just learned so much watching you guys. It's been really enjoyable. I think the one performance that really stood out to me was the defense's closing argument. I thought that was really persuasive and very good. And I think Logan, sorry, I can't see your full name. It just says Loga, but I assume it's not Loga. I thought you handled the technical difficulties really well, just, dealing with that stress on top of the other stress of the competition was impressive. So everyone I thought did a great job. And yeah, thanks for letting me watch it, you guys. That was great.
Thanks very much. Briefly from me, I'm Ian McCarter. I am currently the town attorney for the town of Windsor, Colorado. I have coached mock trial, I have judged mock trial, I have scored mock trial for close to 20 years. This is one of the best performances I have seen, and a really balanced set of opponents. Just a handful of things for the prosecution, and maybe it's just not done in a virtual environment. But what I did not hear was any of the prosecution witnesses identify the defendant as the person that they were prosecuting, nor did I hear any evidence on where, in what city the crime occurred, which is those are important elements, that the defendant is identified by a witness and that the location of the criminal conduct is also identified. And maybe that's just, certainly on the ID, I can understand why that didn't happen in a virtual setting. I did also want to say that Ms. Kidder, you recovered well from the objection being sustained, the objection from Mr. Winton about your expert's qualifications. You backed up, you qualified your expert, and you moved on. So think about that. This is for all of the lawyers, that when you run into a jam, sometimes it's best to pause for a second and back up and try again. And I did see that with many of you today. Mr. Winton, I thought you showed great tenacity, sticking with that witness, that you had a difficult witness, and I think you did an excellent job of that. The one objection that I'm not sure I handled correctly, it was the objection to the character of the alternate defendant, the guy whose dad said, you know, I'll get you, victim, I'll get you if it's the last thing I do. There was an objection to that person's character. And as you may have noticed, I was looking at the rules. I still think it's character evidence. I still think it's inadmissible. But if you go through this competition further, I want you to study that. Is the character of the empty chair, we call it in the defense world, is that person's character admissible? And if it's not, you got to figure out a different way to get to whatever that person's involvement in this case is. So I did want to point out that I may have struggled a bit on that objection, resolving that. Ms. Mulcahy, I thought your testimony was convincing. Your portrayal was convincing. You were obviously well prepared. You were a difficult witness. And then lastly, Mr. Hernandez, I shut you down in rebuttal. I have personal experience of this because my son, when he did mock trial at the state competition, did the same thing you did. Failed to reserve time in rebuttal. And lawyers, you got to make sure when you're closing for the prosecution that you do that, because my son, Drew, when confronted with that, the judge said, Mr. McCarger, what do you want me to do about this? And my son said, well, Judge, it's up to you. And the judge said, okay, that's right. I'm going to deny you the opportunity to rebut. So I wanted to point that out because it felt unfair, but you have to be familiar with the competition rules, especially when it comes to that. Overall, I would say this was an excellent performance. Take some time to relax tonight because you're going to have a long day tomorrow. I want to thank all of you. And if anyone has any follow-up to how I handled things today, you can find me at the Town of Windsor, and I welcome any questions or comments you may have. If there's nothing further, then I will again thank you. I applaud you for your performance today, and good luck to all of you. The court stands adjourned.
Thank you so much.
Very well.
Thank you, Your Honor.
You're very welcome. You're very welcome. Ashley, what do I do now?
Thank you
for helping as well. Sorry, what was that?